May I have your lordship's leave to Milord to file a WP elective without the certified copy of the order.
Original side we are now taking up. That's the difficulty. Yes, our officers. Yes, please.
Milord, if your lordship pleases to fix a date, Milord, the urgency is this, Milord, pursuant to the direction of the Honorable Supreme Court,
Whenever
Milord,
the file is sent, we generally give it in the list. Whenever the file comes, it will. Leave is granted, you file it.
Lordship, it's a humble prayer for the inclusion of the matter.
Appellate side or original side?
Appellate side.
Wait for the appellate side bench to be taken.
Much obliged.
My lord, item numbers 1 and 2, I appear for the respondent number 1.
Yes.
I appear, Milord, for the appellant. All I ask is, Milord, for a minute's accommodation. Milord, my learned advocate on record is on the way. Milord, it's ready. A minute's accommodation, my lord.
You have to just file your written.
Indeed, Milord. That's why
For
I'm.
that?
Yes, just a minute's
No,
accommodation.
we are closing the matter. We are granting you leave to file it during the course of the day.
Milord, grateful.
My lord, we've brought our written notes. May I hand over the copy of written notes to your
Yes,
lordships?
Yes.
And lordships, we've also prepared a judgment compilation for your lordship's convenience. It has all the judgments that have been relied on by us.
Great. Thank you so much.
Lord, these 2 copies, if I hand over.
You are for all the respondents.
We are for respondent number 1.
One is the main contest.
Main
The other respondents were defendants in the.
Oh, right.
Only one party is essentially changed in the appeal.
But I'll file the note shortly.
Yes. Written notes of arguments filed by the written notes of argument filed by the contesting respondent number 1 be kept on record. Full stop. On the prayer of learned counsel for the. You'll incorporate the name of Mr. Bose also today.
Milord, I don't think required.
On the prayer of learned counsel for the petitioner, leave is granted to the petitioner to file its written notes of arguments during the course of the day. Hearing is concluded. Full stop. The matter is reserved for judgment.
Grateful, dear lordship.
Oh, usual order delay.
Lord, I appear for the respondent.
Yes.
Lord, I understand Mr. Ghosh will finish his argument today. But it's embarrassing for me, my lord, but lordship accommodates me for the day because, my lord, our briefs, my lord, in this transition from, my lord, iPad to this, there has been some difficulty. We have got it, but I got it today.
Mr. Chaudhary will, if Mr. Ghosh finishes.
My learned friend will finish today.
He will probably finish. Mr. Ghosh
Yes,
is
yes.
very succinct. I mean,
Yes, yes, my lord. I know that. I also
obviously
told
you
him.
know Mr. Ghosh needs
I
a certificate for. So very well. So very well. We'll keep it on the next
Deeply up.
Wednesday.
Deeply up.
No, someone should take notes for.
Yes, yes. My juniors are there, my lord.
Thank কি not today? কিছু not today না দাও এটা উনি আর্গুমেন্ট করবেন
না not today হচ্ছে না
নোটসের এগুলো আগে দিয়ে দাও পরে ফাইল দেবে ওয়েট করে রেখো না আমাদের যে নোটসের কাগজগুলো ছিল একটা আমার হাতে লেখা নোটস ছিল এর মধ্যে এটা কোথায় গেল হ্যাঁ এখানেই আছে স্যার ওনারটা দিয়ে দাও পরে ফাইল উনি যেটা বলবেন সেই ফাইলগুলো দেন আমি সেটা ধরে ধরতে আর্গুমেন্ট করে সরি মিস্টার ঘোষ প্লিজ হ্যাঁ ডিপার্টমেন্টের লোককে ডেকে পাঠাও এখানে মামলা চলাকালীন আমি কথা বলবো এক্ষুনি ডেকে পাঠাও এখনই ডেকে পাঠাও আমি মামলা চলাকালীন কথা বলবো ডিপার্টমেন্ট কেন আসুন কে বড়বাবু আছে ডেকে পাঠাও Yes, please continue.
Lordship may be allowed to file the copies of the Order 40 and Rule 27 application and the reply, which was missing in the records.
Opposition. No, what are these? The application you are filing today?
No. Application was filed, it was missing from the records.
Oh, right.
Asked us to
Opposition you had filed.
all
test out your lordship directed.
The opposition was previously filed.
Yes. I file a reply to that. The records are because the transition.
So that application, opposition and reply, you are filing the copies today.
Yes.
একটা লাইন নিয়ে নিন আর যদি এটা আপনি চলে যাওয়ার পরেও কন্টিনিউ করে তাহলে এটা ওকে বলে দিন Learned counsel for the parties hand over copies of the application under Order 41 Rule 27 within bracket for production of additional evidence bracket close and the connected affidavits hyphen দেবেন না in opposition and reply. Full stop, those may be kept on record and be treated to be the originals, comma, in view of the originals missing from the file. Thank you.
Well, if I may take, well, I've given you lordship the facts on the last occasion.
Yes.
Now the question is, there was a eviction proceeding against Lolita Sadhukan. We have come to know that after 92, when they filed, Calcutta Port Trust filed execution proceeding against Lolita Sadhukan, and they came to execute the decree for taking possession of the suit premises. And we resisted. The appellant resisted.
Yes.
Now, my lord, we could not produce it, and my humble submission is essential for the court to come to a proper adjudication of the disputes between the parties. It's a lot of the whole argument turns substantially once the documents, your lordship, have a look at it. May I show your lordship the documents I wish to rely upon?
This is on the order for Rule 27.
227, yes.
Okay, copy.
Order for
You
Rule
file
227.
will
But then I can proceed, my lord,
Understood.
on the main petitions more,
Understood.
more effectively.
Yes.
If your lordship be kind enough to come to page 74.
So the original certified copies and orders, the certified copies are with you.
It
The
should be-
originals are there. If necessary, they can be produced. Good. Yes.
we are a bit scared now to produce anything because they're all getting.
Please don't. We are also not confident after the main things being lost. So keep it with you. We just ask
Yes, yes.
because you know for
Yes,
propriety.
yes. My Mr. Gupta is very
So we know.
good,
We know.
yes.
Yes.
Well, kindly come to page 74. This execution application was transferred to small causes court by some procedure in the city civil court.
Yes.
And your lordship will find his execution case number 43 of 2003.
Yes.
Board of Trustees for the Port of Calcutta petitioner versus Lolita Sadhukan. Now, if your lordship comes, these are all matters of record. 5/12/91. রাজেশ তুই পড়ে দেবে প্লিজ, আমি পাচ্ছি না, তুমি দেখে দেবে, তুমি পড়ে দাও পেজ 75 থেকে। পড়ে দাও। No, you put it up. But will you give lordship give leave to Mr. Gupta to read it? Because it's impossible. You put it up, সব কটাই। No.
It says order 1
Yeah. Files and application.
files an application
Yes.
for execution of the decree through so and so of this case registered. So this was registered, and finally, if your lordship comes to page 110, the same was disposed of and dismissed for default on 9/6/2005. Where we have filed the written objection and the written statement was filed by them. And after that, it was dismissed for default. Miss case number filed by the defendant is dismissed for default. আর কিছু বলতে হবে? দেখো দেখেন লাভ নেই তো। Dismiss, it is dismissed. So all the pages in between are the order sheets, all the records of order sheets. If you want, I can place.
Yes.
Order 25.
Yes, yes.
Yeah, we were added as a party. We are given written objection, and then it was dismissed for default.
Mr. Ghosh is wanting you to show the addition of party order.
No. We were the only one who was added as party.
So then
We resisted and order.
you can start off from there, Mr. Ghosh, if you want. You have seen
In
it's-
fact,
it was
at page,
dismissed.
lordship comes to page 60, we had filed a written objection in this. Page 60.
Page 112.
Yes.
You were not in possession.
Yes.
Now, my lord, kindly come to page 112.
Yes.
Page 113.
13, right? 2197
Yes.
for police.
And the way opposite party number 2 is we are the opposite party.
This was filed
Page 112.
the 9th of June. It was dismissed for default. 9th of June 2005. So this had been filed prior to that. Obviously.
Prior to that.
Yes.
This was filed to prior to that, where we are the party JK Oil, OP2 on page 112 at the last.
You are not the judgment debtor.
We were not the judgment debtor.
So therefore, your objection was in the nature of Order 21 rules up to 101,
Yes,
97 to 100.
So that's why we came before this court in the writ jurisdiction.
Right.
And we were protected that we should not be evicted without due process of law. And that's how we objected here.
Now you came up before the writ court exactly playing what? That you should not be evicted without due process of law.
Yes.
But you already had that Order 21 101.
This was afterwards all this. We came to know first time for the decree when they came to evict us.
Yes. Then you preferred a writ first.
Yes, we preferred a writ first.
In the writ court, it was.
We were
what
given
happened to the writ?
The writ was disposed of, directing the port trust not to evict us without due process of law.
By then they had filed the execution case already.
Then they filed an execution.
No, they had filed.
They
You
had
did
filed
not.
an execution.
You did not. So without due process of law, so you went back and filed this order objection. Correct.
Then this execution was dismissed for default. There's some important days which I'd like to just 1974, 23rd December 1974, Port Trust filed a suit for ejectment.
Pardon? Who filed?
Suit for ejectment
Against
against Lalita Sadhukan. Decree was passed on 20 December 2012-79. Execution against the said was filed on 5th December 91. After that, when they came for eviction, we came before the writ court by an order dated 24th September 1992. We were protected. Our eviction was protected we should not be evicted without due process of law. On 9th June 2005, the execution proceeding was dismissed for default.
9th June?
9th June 2005.
Oh, yes, we saw that case.
Column 3. Dismissed for default.
Yes.
CPC now, CPC.
Yes. Which provision, Mr. Ghosh?
Order 41, Rule 27. Well, particularly B.
Yes, B. Court can.
Because well,
So do you say B overrides A and A?
that's where I was unable to produce it for the reason that they were missing from my custody. Well, what happened in this case, my client, who really, he's very old now, and he's suffering from tremendous dementia. I've given all the pleadings, and I've got all the certificates from the medical that dementia, kept it in the drawer. He forgot all about it. When it was-
So
it was-
dementia papers are annexed to this order for
No, I've not. I've because
you
he,
have pleaded dementia here.
yes. You know.
So AA is also covered, 27 AA,
Yes, I've covered.
and B, you say these are German, so the court should
It's
consider
very
for
important for
both AA
proper
and B.
adjudication of the dispute.
Right.
That's the reason. And what I'm relying upon are purely matters of record of court. AO, if it takes a,
That's why we asked you whether you have the certified copies. You have the certified copies, it gets a better status. If you have a certified copy of the order, a certified copy can be looked into. I mean,
yes, yes,
subject to what Mr.
Yes.
Chaudhary or they say.
yes, I've got all certified copies. Unfortunately, the gentleman, Mr. Ashok Sarkar, who was an advocate in Citizens Court, he had passed away.
Ah.
That's at a very young age he passed away.
Well, Mr. Ghosh, you can start relying on these or whatever you are arguing.
Yes, AO, if you also take the affidavit in opposition,
Yes. What is the main stand in the opposition?
main stand is,
Yes.
just I tell you, Doctor, with reference, this is all through 16 to 19 of the petition. They even accept what are matters of record, what will appear from the record, order the allegations and denied. I'm only relying upon record and what appears from the record.
Very.
And the affirmation is in para 12, the statements contained in 110 are all true to my knowledge. So you knew about the proceedings by CPT against Lolita Sadhukan. Respondents knew.
No, he knew that apart from what are matters of record, he is denying. He knew this much. Yes. But yes, so this is a, I mean, bald denial sort of. So no, practically no denial on facts. But on A and B, definitely he will be arguing. That is a question of law, so no question of evidence.
Now he is also annexed.
Yes.
The respondent in page 30. He is also annexed
Yes.
from the order sheet, page 31.
31, yes.
From the order sheet.
Dismiss for default.
Dismiss for default. We red item.
So it cuts your job by half.
We red item.
Fair enough. Yes, yes.
To judgment कीजिए yes. You know, बादल
79.
पूरे आ गया page 18. Page को तो page है
601.
yes. Well, first judgment I'm relying upon 1979, volume 2 SCC 601.
Yes.
Paragraph
23.
Kindly come to my lord, paragraph 23 at page 614.
Yes, Mr.
It was contended by that the High Court was in error in granting CMP, permitting the heirs of the defendants so and so to produce the sale deeds, which they did not produce at the trial court. And after relying on the same, reversing the decree of the trial court. The High Court has given cogent reasons for granting CMP 22762 of 61, Order 41, Rule 27, CPC, enables the appellate court to admit evidence in the circumstances or situation therein, or situation mentioned, one such being where the appellate court required the documents to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. By a catena of decisions of this court, it is well established that Order 41, Rule 27 does not confer a right in the party to produce additional evidence. But if the court hearing the action requires the document as it is to enable it to pronounce judgment, it has the jurisdiction to permit additional evidence to be produced. The High Court has given cogent reason as to why it is impelled to permit.
Mr. Ghosh, we have read this paragraph. Need not take the trouble of. We have read. So if the court needs, the Supreme Court did not interfere.
Yeah.
And cogent reasons were also given.
Yes. And I should trouble you not to give one more judgment or
Yes.
two more judgments.
Yes.
The next one is
2012.
140 Paris. My next judgment is 2012, Volume 8,
Yes.
Supreme Court Cases, page 148. At page 170, paragraph 47. I will, no, sorry, 48 and 49. To sum up on the issue, it may be held that the application for taking additional evidence on record at a belated stage cannot be filed as a matter of course, as a matter of right. The court can consider such an application with circumspection, provided it is covered either under the prerequisites of conditions incorporated in the statutory provision itself. The discretion to be exercised by the court, judiciously taking into consideration the relevance of the documents it requires to be of the issues involved in the case and the circumstances under which such application evidence could not be led in the court below, and as to whether the application had produced his case before the court below diligently, and as to whether such evidence is required to pronounce the judgment by the appellate court in case the court cannot be comes to the conclusion that the application filed taken up the record. However, the court must record the reason as to why it has given the application has been allowed. However, the application should not be dismissed, that it should not be moved at a belated stage. An application 49, an application filed under Order 41, Rule 27 is to be considered at time of hearing of appeal on merits as to find out whether the documents under the evidence sought to be adduced have any relevance or show bearing on the issues involved. The admissibility of the additional evidence does not depend upon the relevance of the issue on hand or on the fact whether the applicant had an opportunity for adducing evidence at an earlier stage or not. But it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment on any of this or any other substantial cause. True test is, therefore, whether the appellate court is able to pronounce judgment on the materials before it without taking the consideration of the additional evidence sought to be adduced. Such such occasions would arise only if the examining the evidence as it would, the court comes to the conclusion that some inherent lacuna or defect becomes apparent. The court as the court. Then they relies upon some of the judge. These are two judgments I'm relying
Yes.
upon. But there were three of them. I calculated the next judgment I'm relying upon AIR 2003 Calcutta. It's a division bench judgment, page 263. Para 8 at page 268. Opinion number 2 at the bottom of the
Yes, Mr. Ghosh.
right at the bottom. The
Yes.
different number 2 appellate has filed an application under Order 41, Rule 27. The document sought to be adduced as additional evidence has been made part of the application. From the said application, it appears that the documents relate to records of the court and certain registered documents, receipts, and challans in connection with the various suit and execution cases relating to the property. Some of those documents are pre-suit, some are pre-hearing, and few are post-hearing, post-decree. Admittedly, majority of those documents were in custody of and power of the defendant number 2, but it had not attempted to adduce the same in evidence. But the facts remain that until the decree was passed, the law was governed by the decision of the single judge by reasons wherein the defendant number 2 could not contest the suit on the question of absence of readiness and willingness of the plaintiff. Be that as it may, from the perusal of these documents, it appears that these documents are relevant for the purpose of proving either the readiness and willingness of the plaintiff or with regard to the question, the time and essence of the contract. And to our mind, it appears that these documents might have been important bearing with the with regard to the exercise or discretion by the court as contemplated under or section under section 2 is a specific relief act or section 20 of specific relief act. So these are the recorded documents were records of the court.
We have read it, Mr. Ghosh, substantially. So, under Section 20 of the Special Relief Act, it was the bounden duty of the court to consider readiness and willingness, which is why this was considered to be necessary by the court. So, irrespective of AA was considered here and said, although some justification was given because the defendant number 2 was debarred in that case, but still, invoking B, court has taken it.
Yes.
Without that, it was not possible. It was
For
the bound.
sufficient cause, yes.
Yes.
The last judgment below is also a division bench judgment. AIR 1986, Calcutta 403. 403, sorry. 403. We paragraph go to issue. Paragraph below, paragraph, big longish document. 25 and 26.
Yes,
Same reasoning.
same.
So the court accepted it. Your Lordship takes page 413, left-hand paragraph.
Now, very importantly, next page, the left-hand margin, the margin which has been marked, there may well be cases after the quotation, after AIS 63 quotation, there may be cases when even though the court finds that it is able to pronounce judgment on the state of record as it is, and so it cannot strictly say that it requires additional evidence, it still considers that in the interest of justice, something which remains obscure should be filled up so that it can pronounce its judgment in a more satisfactory manner.
Yes.
Such a case would be covered.
Yes.
So it makes it wider.
Absolutely.
So, in fact, because the previous judgments say that if it is not possible to deliver the judgment, basically without that.
Yes.
But here it says no, even if it is possible otherwise,
That is why I went a bit further.
interest of justice, something obscure should be clarified. Court can do it under B. Yes.
And below paragraph 26,
26 also, we also feel.
gave 1, 2, 3 reasons
Yes.
on the right-hand column.
Yes. Yes. Yes.
I'll take the middle of right-hand column middle below.
Yes. Yes.
And thirdly, the courts considered the necessity for such production for any other substantial cause, which in our view will also include the question of doing proper and substantial justice, including the case for ends of justice. And while making an order for any reason, as mentioned above, the court must be satisfied that for some good or sufficient reason or cause, the concerned evidence could not be produced before the trial court. The courts sometimes have right, authority, and power to refuse admission of additional evidence if the action is not bona fide or intended to fill the lacuna of the evidence. The last part of the power of the court will not apply in this case, since we are satisfied for reason duly explained. The concerned letters in this case could not be brought in evidence at the trial of title suit number 12.
But this goes a bit against you because it makes B subject to AA.
No, will you kindly state this?
The courts at the same time have.
Last part of the power of the court
Yes.
will not apply in this case, since we are satisfied, in a particular case on the facts, since we are satisfied for reasons duly explained, the concerned letters in this case could not be brought in evidence at the trial of title suit number so and so. If I can satisfy that is for reasons.
Here it is said, Mr. Ghosh, we are just taking your liberty and just.
Yes.
Thirdly, the courts consider the necessity for such production for any other substantial cause, which in our view will also include the question of doing due, proper, and substantial justice, including the case of ends of justice. And while making an order for any reasons as mentioned above, the courts must also be satisfied that for some good or sufficient reason or cause, concerned evidence could not be produced before the trial court. So that somewhat makes it subject to AA also.
Somewhat.
But you have to take a reasonable view. I mean, collating all the judgments, basically court can if it feels that there is, it requires it. And for substantial justice that is also.
Those are the judgments below. So far,
Yes.
order
Order
41
41.
27 is concerned. We have got all the original copies.
Yes.
Right from we have produced when the suit was filed, decree was passed.
What are the documents you are relying on? The orders passed in the execution case.
No, all the suit matters also.
What is the relevance of that, according to you? Particularly, what are you relying on those for?
Because we have to show that when the matter was pending in this court, Lolita had already suffered a decree for ejectment. That was passed on 2012-79. The suit was filed on 22/12/1974.
Yes.
I'm bringing I don't want to leave out any document to show that the decree was passed long time back and they knew about it.
Page 35 is the
Page 35.
decree.
I will kindly take page 35 of my petition.
Yes.
PPT versus Lolita Saduka. Recovery of cars possession, scope, scheduled to the property.
Yes.
Then kindly come to page 39. Whatever documents are there, we have brought everything for your lordship. Joint petition on behalf of the parties, and they agreed to kindly take F on the following.
Yes, F.
Page 42.
42. I will kindly come to page 42.
Yes.
We wrote a letter to Kolkata Port Trust.
So this is a new document. This was not a part of the. This is not a certified copy or any order.
This is a copy of the letter.
Your.
My letter is, and we have said very clearly, kindly take page 44, paragraph 9 and 10. Then they asked for police help because we were the only one who resisted. Nobody was there, didn't find anyone. If your lordship takes page 55. Para 1, Thomas Kumar Ghosh, land inspector, Pransu, going to the south side of Crossroads, want to take possession. 2, that the defendant judgment debtor, opposite party number 1, was not found in tenants in suit, and the Balaram Sadhukan carrying on business as proprietor of JK Pure Oil Mills on behalf of the defendant wrongfully, illegally, and without having any right whatsoever resisted the court's counsel. And they wanted police help. And this was built on sometime in 92. After this, we came to court. When we resisted, we came before Justice Mitra. I've given her all the documents,
Yes.
so they're not holding back anything. You also get a complete picture. And they were not in possession. That's very important. They cannot be put back in possession in view of 2001 Nimani case. In fact, in my humble submission, after the decree for possession, after lease expired, we have lost, all of us have lost any right to stay on the suit premises. Both respondent Lalita Sadhukan and sublessee and sub-sublessee. We didn't have any right, only because we had to protect our right by coming to court and taking the protection of court till they evict us by due process of law upon notice to us. That was the scope of Justice Mitra's order. We give you the order is there, volume 3. Huh? Volume 3 page. Volume Volume 3. Justice Mitra's order is at page 657. We moved it upon notice to Port Trust. Mr. Mazumdar appealed for the Port Trust. The order was passed on 24th September 1992. Having heard the learned advocates for the parties and going through the facts and circumstances of this case, the writ application is disposed of by restraining respondents from taking possession of and or interfering in any way with the petitioner's possession in a disputed property without starting appropriate proceedings in accordance with law upon prior notice to the petitioner. The respondents, however, do not admit any of the allegations. This is scope of the order. It is not a blanket injunction.
So according to you, this was not resorted to by them. Due process was not resorted to by them.
No. They went to Order 21, Rule 98. They added me as a party with Shalita Sadhukan, that I wrongfully resisted them. I showed you that petition they made. Yes, you Calcutta Port Trust. They could not find the judgment debtor in the suit premises, but one Balaram Sadhukan, proprietor of JK Pure Oil Mills, resisted them. And that matter eventually for prolonged days, because they Port Trust dragged it, and then ultimately it was dismissed. Even after that, they did not start any proceeding. They could have.
You had taken out an application, that written objection of yours filed in the execution case. That was in the nature of an application under Order 21 Rules 98 to 101.
Yes, well, because when they served it upon us.
So adjudication of that and taking possession pursuant thereto, wouldn't that be a due process of law, Mr. Ghosh?
Yes, it should be, but that
That was not even done.
Petition was dismissed.
Your objection, what happened to your objection? I mean, you took out an objection, we found.
Yes.
Objection in the nature of resistance under Order 21 Rules 97 to 101.
Yes.
So that was decided,
That was decided by, no.
not on merits.
Not by the default. They did not appear, CPT. CPT did not appear. Opportunities were given to file affidavit.
Yes.
What we said. We thought was
Mr. Ghosh, what was the independent right set up by you? Because 90 to 101, you have to set up an independent, you cannot claim through the judgment data.
I'm not claiming the judgment data.
What is your independent right?
I said that I've been carrying on.
Wrote for, you asked for a long-term lease, that was not given to you.
Not given to me. I said that I've been carrying on business for a long time. It came to Justice Mitra, relying upon it as far as the resolve allowed, Marfata's case with the Bombay Port Trust, that statutory body should not behave like a private landlord.
Right.
So therefore, I said, give me some time. I've been carrying on business so long. All of a sudden, they came and said, wanted to throw me out. So Justice Mitra said, okay, I will give you time. In other words, they said, you carry on. You start proceeding as Mr. Ghosh's client upon giving notice to him.
When had you filed that objection under 2190 to 100? That date? Prior to Justice Mitra's order or after? That is what we want to know. Page 60. Page 60. Yeah. It will be at page 60.
73.
Mr. Mitra says
73. On page 73.
73 is the date. Yes, thank you.
Thank you. Para 20, that order is mentioned in this application. Order of the read
Part
court.
20 of the present impugner.
No, of the order of the court, read court, allowing us in that application.
Oh, acha.
Page
Para 20 of the application, the order is. So must be after. And it's after. Yes, well. So pursuant
page 69.
yes, pursuant to that you have filed. So this was decided ultimately, not decided.
Not decided.
No, it was not decided.
What happened to this objection?
It's still lying over there. Because both parties lost
Never
interest.
decided at all.
I don't think so. But
At least to your knowledge, it was not decided.
from the whatever got the certified copies, because I was told all these are certified copies. That's the entire records produced, including we have the plain and the written statement of the CPT and written statement of Lolita Sadhukan. Everything was produced. Kindly take page 71, paragraph 26, part of that petition or objection.
Yes.
That the decree passed in ejectment suit number 72 and in that was 1974 against Lolita Sadhukan.
Yes.
Long before they filed the suit in Calcutta High Court. The instant proceeding has been initiated as long before 24th September 1992, and the decree holder stroke petitioner has not been initiated any fresh legal proceeding against opposite party number 2, any court of law to evict after 24th September 1992 or until now, as per the direction of the Honorable High Court, Calcutta, as such, as the proceeding is bad and not maintainable against the opposite party number 2. Opposite number 2 submits as a decree passed by in the ejection suit number 2 passed against Lalita Sadhukan, wherein opposite party number 2 was not included as party, as such the decree passed in said suit cannot be binding upon the opposite.
Now, something against you, Mr. Ghosh, we are opening our mind. Apparently, on a proper, meaningful reading of Justice N.K. Mitra's order, it transpires his lordship observed that you cannot be evicted unless due process of law is initiated and notice is given to you. Now, we may read this because in law, because at that juncture also execution case was pending when Justice Mitra's order came. If an execution case is pending, law demands that you have to go in the self-same execution case and take an objection, and that has to be decided on merits. The order has the trappings of a decree, etc.
That is dismissed.
Yeah. So therefore, according to us, prima facie, no further eviction suit was. Otherwise, every time everyone was required. So that objection had to be decided on merits.
That was dismissed. I still say, my lord, I told Justice Mitra, they can initiate proceeding under public premises. Unauthorized occupation.
But since they were enjoying a decree and you are a judgment register and you took out an application under Order 2097 to 101, that objection. So wouldn't adjudication of that itself on merits be due process of law for this purpose?
That's right. That's right.
Because a new evictions, initiation of a new eviction suit or a proceeding under Public Premises Act probably would be contrary to the principles embodied in Order 21, that ecosystem, 97 to 101. Or 100 up to 103, you may say. Because a new suit, then every time somebody resists in an execution case, you have to.
No, I'm not in that. I personally.
So you principally, yes, you agreed to this, that on merits, if it was adjudicated that your objection, treating it to be one under Order 97 to 101, that would be sufficient compliance of due process of law.
Yes. Yes.
That would be a reasonable view, because otherwise, every time.
They took I've disclosed this by all the documents.
Yes, yes.
Time after time, they took adjournment. Eventually, the court gave them a particular date, particular time. Even then, they didn't turn up. I mean, CPT.
Right. So when the execution case was dismissed for default, also at that point of time, also that objection remained pending. Then
but we laid there. That was part of our execution. We said this is our objection.
All right.
Of course, I was not there. I can say only from the records.
Very well.
But it was very well handled by Ashok Sarkar, because you're going to the small causes court.
Yes.
But I am not very sure whether, I must say, whether the court trust, even after this, could have initiated proceedings on the public premises. Because that is independent law, independent court by itself. I'm not sure, but whether they could have initiated.
So you have an alternative argument on that, then he would be at best an unauthorized occupant under the 1971 Act. So therefore, they were required to initiate a proceeding.
Yes, they could have. I don't think it was barred by res judicata.
No.
Because the unauthorized public premises, unauthorized occupation act has been said it's a code by itself.
Yes.
Everything is there, laid down, even to the appellate authority. And that is the Punjab National Bank's case. No proceeding has been initiated against the appellant at all by CPT. And to show that our bona fide, we send them 2 checks of 1 lakh each, that, take it, make us a tenant. directed it. No reply to that. Although they didn't encash the check. There is a, your lordship knows there's a principle in estoppel that when there's a duty to reply and you
Yes.
don't reply, then that's a estoppel against you. And Spencer Bauer has a very good treatment of this. When you have a duty to reply and you don't reply, then it's an estoppel against you.
Why do you say duty to reply? There is no statutory duty to reply
No.
or contractual duty to reply. Duty,
Circumstances show that he's asking. I've given the check.
suppose you ask something, you ask for a renewal of a lease or something. I simply sit tight over the matter. I don't deem it fit to reply even. How can
It
you
all
say that?
depends on circumstances of the case.
Depends on the circumstances.
Circumstances of the case.
Yes,
I have given him 2 checks.
they received the checks.
Yes.
Did not return. Did not encash, but did not return.
Admitted position.
All right.
Because this is a corollary to the, usually we say that if he doesn't reply, that doesn't mean that he's accepting the truth of the writer's letter. Suppose I write a letter to Mr. Gupta and doesn't reply, that doesn't mean he's accepting the truth of what I've written. But circumstances may be such that unless he replies, he seems to have been accepted. That's the treatment in persuasive.
But isn't there to be something over and above this? I mean, subsequent receipt of occupation charges or rent from you, or something to show that they acquiesced.
Before, we gave it to him immediately sometime in 96.
You gave the letter, you gave 2 checks. They did
Two
not
le-
encash, they did not return but did not encash. And they never took any rent from you further.
No, they didn't.
Because in absence of something else, whether estoppel could apply squarely.
No, I'm not saying what I said.
Estoppel is a third alternative argument.
That I'm not arguing that.
Understood.
I mean, there is one proposition. If CPT appeared, I would have asked them. But why didn't you?
Yes.
You are a statutory body. I've given you a.
That remains. They have to act on a higher pedestal than an ordinary citizen. Definitely.
So this is my on order 41, rule 27. I argue such a no. So if your lordship allows those documents, your lordship will get a clear view of the whole thing.
No, you're concluding your arguments on the appeal also. Appeal as well as the order for
No, it's only an order for
order for 2020. So let us hear you on the appeal, proceeding on the premise that we accept these. Because we'll take it conclusively from you, your arguments, and then hear them.
Yes. After hearing Mr. Chaudhary on order 41, rule 20.
No, Mr. Ghosh, we want a conclusive hearing from you. Proceeding on the premise that order for 27, if it is allowed and we look into the documents.
Yes, then I'm coming to the.
You make alternative arguments if you look into the documents or without that also. So make your arguments conclusively and then we'll go to
I'll go to straight down to the appeal.
Yes. On merit, without these documents and with these documents, you make your arguments.
Without these documents, I've already argued.
You've already argued exactly.
Before the trial court. But then I've got one thing to tell you, Lordship, before the trial court.
Yes.
Trial court is judgment.
And we'll just request you to be pinpointed because we have a heavy list, which we believe that you are very succinct. We don't want to cut you short. You argue to your heart's content, but just keep it to the point. Because of we hate to say this to counsel, but we are helpless rather in view of because this bench is sitting taking up only the specially fixed and assigned matters, and the list is quite long.
I know. I'll try to.
45 matters assigned to a non-regular, original side bench. That's a difficulty.
I want to judgment as a. Oh, God.
My brief is missing.
Hey, Badu. All one. Please withdraw. Will you kindly take volume
Yes.
2.
Yes.
The trial court judgment starts at page 276.
একটা বাঁধিয়ে দেন হ্যান্ডেল করে ইজিয়ার we'll request the we'll request my brother to pass judgment because you have not bound his volume.
You see?
My learned brother's volume is not bound, so I'll request him to pass the judgment so that he's already prejudiced.
This was the second reconstruction of the records. The
This is a
second
record
cop- This was done by the
Alright.
court.
And not only that, that's more that's handier than this actually. Which page? Sorry, we missed the page. Which page is the
Yes,
imprint?
I'm coming to it.
Oh, right.
The sir, the judgment starts at 276. No? 276.
That's volume 2 of the other appeal.
Other appeal must be there. Yes, exactly.
183.
তাহলে 182 টাই ফলো করি চলো। So you will be arguing on the other appeal paper book. We'll follow that paper book then. এটাতেই মার্কিং ছিল এক্স্যাক্টলি। এইটা বাঁধা এইগুলোই দেবে, হ্যাঁ এটাতে পেজ মার্কিংও রয়েছে। তুমি দেখে নেবে এরকম হলে যেটা ফ্ল্যাপ লাগানো আছে সেটা দেবে, কারণ তার মানে সেটা আগে হিয়ারিং করেছি তারা। ইয়েস, ওটা চলে, ওটা আজকে লাগালাম তো। দাও দেখি দেখি হ্যাঁ দুটোকে দেখ, দাও না দাও না ওটা যেটা ফ্ল্যাপ করেছি। Give us half a second. The order of Justice Mitra is there in their opposition. It's there. Well, is that there in the paper book of this also? Because we cannot follow two paper books. It's very cumbersome. You just find out while Mr. Ghosh argues Justice Mitra's order whether there is there in any volume of this APO 83 183.
Actually, I'm handicapped today. I've lost my brief today.
Great. তাহলে রেখে যাচ্ছি, ছাড় পাঁচ ঝামেলা গিয়ে এটা থাক ওটা থাক।
Justice Mitra's order is at page 657.
657.
Yes.
Thanks.
Volume 3.
T cannot be 657.
Volume 3. The appeal number then.
Mr. Ghosh, leave it. Let us now come to the impugned judgment, which you are placing.
No, this is important. This is very important. Order.
Yes, page 276.
657, volume 3.
Volume 3. Well, yes, you have taken a note. না না এটা তো অন্যটা ভলিউম, এটা তো অন্যটা ভলিউম থেকে মার্ক করি, এটা অন্যটা ভলিউম।
Actually, for convenience, I would prepare a compilation. I would prepare a compilation of the documents we cease to rely on so that, you know.
So that will make it more inconvenient. So we will have to follow 3 lines then. Leave it. We'll follow the paper. Yes. Yes, Mr. Ghosh, please advance your order. Page 276, the impugned judgment.
Kindly, I placed this judgment on the last occasion, but then a few things I would like to point out.
Yes.
This I argued without the whole argument turned because I didn't have those documents. That whether I could challenge the title of the landlord or deny the title of the landlord without going out of possession on the threat of eviction. Because there is no doubt that CPT has already initiated proceeding against Lalita Sadhukan. Now your Lordship will see the judgments that I had shown will appear at page 286.
Yes.
The question turn whether the Lordship comes. Question to page 289.
Yes. 289.
Defendants contended under section 116 of Evidence Act. A tenant, due to the continuance of the tenancy, could not deny the title of landlord. They, however, contended that such principles do not apply to prevent the tenant from contending the title of the landlord since then has come to an end. According to defendants, the true owner, armed with the original process of eviction, though the tenant was out of possession, the threat to put him out of possession amounted in law to eviction. According to defendants, in the facts of the instant case, Lalita Sadhukan issued a notice of eviction against the original plaintiff. Although the original plaintiff was not put out of possession, he was never in possession. Respondents were never in possession, nor Lalita Sadhukan. We are the only one who were in possession. And after considering the cases, now kindly come to page 281.
Yes.
Fourth line. The estoppel disappeared. However, if the landlord's title was extinguished subsequent to the inception of the tenancy, or if there was eviction by title paramount. In the instant case, the original title of the original plaintiff was not extinguished subsequently to the inception of the sublease. The notice of eviction issued by Lalita Sadhukan per se was not extinguishment of the right of the original plaintiff. The original plaintiff did not accept the notice of eviction. But by the time she gave notice of eviction, they were already sued for the decree is passed.
Against her.
Yes. The original plaintiff was not evicted pursuant to the notice of eviction by a court of law. The right of the plaintiff, therefore, was not extinguished merely by suffering the notice of eviction from Lalita Sadhukan. The original plaintiff was not evicted by title Paramount Kolkata Port Trust. This is why I immediately wanted the documents. Port Trust also admittedly did not evict any of the parties from suit premises. They were all evicted. I will kindly come to page 294. Right at the bottom, last two lines.
Yes.
From the facts, it would appear that the plaintiff was in possession of suit premises. Totally wrong. There is nothing on record to show that the respondents were ever in suit possession. J.K. Pure Oil Mills, the president was there. Then, kindly see page 295.
Yes.
The deed of sublease expired by efflux of time. No doubt, Lolita Sadhukan terminated the tenancy of the original plaintiff. Nothing on record was shown to suggest that Lolita Sadhukan took possession of the suit premises or had initiated any proceedings for eviction of the original plaintiff, or any decree of eviction was executed against the original plaintiff in respect of the suit property at the behest of Lolita Sadhukan or Kolkata Port Trust. Going by the additional documents and produced, it completely goes wrong. The defendant, the next paragraph, the same page. Defendants failed to establish that the relationship with the plaintiffs to disrupt a de jure or de facto. In such scenario, the defendants were stopped under Section 116 from contending the plaintiffs did not have title to maintain the suit for eviction against the defendants. The first contention of defense that the defendant was not liable to vacate in view of termination of tenancy by Lolita Sadhukan is without any basis. Whole things will get disrupted if those documents are not there. Now, this is important. My submission before the learned trial judge was that I have no right, but I'm protected by Justice Mitra's order. Because Justice Mitra's order clearly shows that a decree has been obtained by CPT against Lolita Sadhukan, for which they wanted to execute. The order dated 24th September 1992, passed in writ petition number 3194 of 1992, allowed the Kolkata Port Trust authorities to take appropriate proceedings for eviction in accordance with law upon prior notice to defendant number 7. It was not the case of defendants subsequent to the order dated 24 September 1992. The Kolkata Port Trust authorities had initiated any proceedings for eviction upon notice to defendant number 7. There was no embargo. He's conscious. There was no embargo on the Kolkata Port Trust authorities to initiate proceedings for eviction. Such order could not be read to me. The plaintiff would not be entitled to evict the defendant for all times to come. The second condition is totally against the facts and law. He's conscious that KPT has not taken any steps against me.
Yes.
Would that mean because Port Trust did not initiate any proceeding against the appellant, does not mean the plaintiffs get the right. Plaintiffs have already been evicted. Lolita has been evicted. I am evicted. All three. Lease has come to an end. Lease, sublease, sub-sublease. So this was the argument without the documents, which makes it apparent the documents are very important for the appellate court to consider.
No, but the court does not apparently deal with the fact that no eviction proceeding, let alone eviction, any due process of law was resorted to.
No.
That is not discussed even, although the Justice Mitra's order is taken note of.
Yes.
With all its connotations.
Yes.
Court says simply that such order could not be read to mean that the plaintiff should not be entitled to evict you forever. Yes, it does not mean that forever they are barred, but they have to resort to due process of law whenever they do it.
Yes.
But after that, I mean, there's a sudden jump probably to the next issue. It's not discussed whether any due process of law was resorted to.
In fact, my lord,
Hmm.
I asked the respondent in cross-examination in view of justice, the execution proceeding, that was any execution proceeding initiated against Lalita? He said no. Do you know the decree of eviction was passed? He said no. Although maternal aunt of the respondents. Then in question numbers 427 to 430 of Shadu Khan, who deposed. Respondent number 1, who deposed before the trial court. The witness admitted that the property belonged to CPT, but denied having any knowledge
47 of the other paper book.
of the deposition.
So 47 is something else in this paper book.
Position is official. What are the deposition? Will you kindly make a note of it? We'll give you Lordship the
Deposition of which witness?
only one witness was there.
Defendant's witness.
Yes, no. I couldn't deduce. My witness was totally unwell. Respondent number 1.
In the index it's written 464. Is it Mr. Maheshwar Pramanik's evidence?
Yes, yes.
Page 464.
Okay. Question numbers 427 to 430. 430.
What is the question number, please?
427.
No, question number.
Question numbers.
Question number 427.
Yes.
Four two seven or 427?
427.
Find it in the-
It was originally 357. It was renumbered by court to 427.
Don't find so many questions here. No, you don't find it.
So in fact, the documents referred of the other, only the judgment is, impugned judgment is referred in this. Volume কত জানো?
427 ওটা।
Volume
এখানে না কোন ভলিউমে? তুই তো দেখলি বুঝে যাবে
Volume
427
one.
কোথায়? কত?
No,
volume
উপরে তো
3,
লেখা আছে কত
volume
পাতা
2
থেকে
হবে।
কত। আরে বাবু তোমার ওতেই তো লেখা আছে কত থেকে কত পাতা। এইটা নয়, অন্য পেপার বুকটা বলছেন। অন্য অ্যাপিলটা। 56 এ একটাই ভলিউম রয়েছে। ভলিউম কেন যাচ্ছে? পেজ বলছেন তো 427। 427 কোন পেজে আছে দেখো। এখনো বুঝতে পারছো না? এপিও 56 এর পেজ 427 টা কোথায় সেটা দেখি না একবার। আমায় দাও। No, pages are not telling. Either of the paper books. No, Mr. Ghosh, we think we will take up the next matter. You just ask your learned junior to just sort out the papers so that we follow this. We are literally on the same page.
Lordship takes it on the other day.
Pardon?
So he takes it on the other next.
Yes, we'll take it on the next day.
Next
So
day.
please sort out the papers in the
I'll sort
meantime.
out.
Go through the
Because I'm
papers.
handing- My brief is stolen.
No, understood. Understood. You can go through our records And you can just take a note of the papers corresponding to Mr. Ghosh's notes. আর গন্ডগোল পাকিও না ওটা করে দিয়ে তারপর আবার 2 মিনিট বাদে আরেকটা প্রবলেম
I'll get back.
heard in part Push-up, during hearing it transpires that there is some discrepancy in the papers, comma, insofar as the pagination of the paper books are concerned. Push-up, learned counsel for the appellants is requested to sort out the issue before commencing further arguments. Push-up, next para. Let the matter be posted for further hearing on July 29, 2026. Learned counsel যেখানে বলুন the learned advocate হলো we have made it the learned advocate. And if possible, if you can please just have a talk with them so that they also get to know which pages you are referring to, I mean, or something of that sort. It will be easier for all of us to conclude arguments on that. Yes, you also collate the papers with him. Next. Mr. Mondoli, help him when he does it. Yes.
Lord, I appear for the appellants. Lord, I'm led by Mr. Abrojit Mitra, learned senior advocate. Lord, I was praying for a short passover.
Password means your chance may be gone.
Then
I beg
We
to
were
differ,
not-
respondent.
Lord,
my
will
lord.
it be your lordship's pleasure to keep it next week then, my lord? What is it?
To the first step it also.
We have concluded our argument with Mr.
No,
Mitro to
Oh, you
reply.
have to
my lord.
argue, right?
Yes, my lord.
Yes.
So, Mr.
And accommodation is sought on behalf of the appellant. Let them stop. Let the matter stand over till July 29, 2026. Stand over till July 29. Yes.
Grateful, my lord.
Thank you. 7 not একটা order record করে none appears for the parties ওখানে বসেও নিতে পারেন ছোট none appears for the parties the matter is adjourned for the day. Yes. Same order. Same order.
Lordship, I appear on behalf of the respondent.
My lord, I am led by Mr. Thakkar, my lord. Kindly make it Passover.
We'll pass over the order record.
My lord, this will be passed over for the day.
We're not sure. Depending on several circumstances.
Passover.
Where is Mr. Thakkar? He's engaged somewhere.
Yes, yes.
Which court? Yeah, any of you can say. Which
Lord,
court?
he is engaged in court number 13,
13.
my lord.
13, who is sitting?
Justice Mantha was to be sitting in 13, but today I do not think he is sitting.
Then the wrong court here. Which court? Judge, name the judge. Judge.
Sir, a short Passover is
Short Passover, he'll have to wait for the day. I mean, we don't know when we'll call them actually. তার একটা ওই same order করে দিন. An accommodation is sought on behalf of the review applicant.
I'm sorry to interrupt, my lord. Mr. Kaur is coming, Lordship.
Mr. Kaur is leading you.
Yes, he's
My lord, then kindly make it Passover.
Mr. Kaur is coming, but how can it be helped?
Lordship.
He has to start. An adjournment is sought on behalf of the একই order. Accommodation is sought শুধু on behalf of the review applicant. His name will be recorded, Mr. Kaur.
I tried my best.
No, there. Mr. Thakkar is not there. Yes, next.
That's what I was. That's why I was.
Lord,
there are a lot of factual issues which have been raised. But 11,
10.
10. 10 we have made not today, Mr. Thakkar is not. 11 who is appearing? Of special lesson matter. কেউ তো একটা ক্লার্ক তো অন্তত থাকবে সেম অর্ডার রেকর্ড করুন সেম অর্ডার পাস ওভার করে আদার সাইড বসে থাকবে সারাদিন নেক্সট সেম অর্ডার এগুলো কিন্তু অ্যাপেলেন্ট সেম অর্ডার ঠিক আছে তাই করুন ওই অর্ধের দেখে নিন We are taking the break now so that people can come. Except those people whose fate has been sealed for the day.
I'm really sorry. We left it between. That's when phone time.
At least some clerk, some sub clerk should be there to follow. Yes. Follow.
I'm led by Mr. Deepak Pollatka, my lord. I'm playing for not today, my lord.
You're for the respondent.
I'm for the petitioner, my lord. Appellant.
On the prayer of the appellant, the matter is adjourned for the day. Not to record, record করতে হবে কিছু। Not to. Same.
But see, by 18 IPA for the respondent, my lord, the appellant has not been appearing for some time, my lord.
দেখি একবার ফাইলটা। Order sheet at least দাও। কিছু ম্যাটার নর্মাল। হ্যাঁ ওগুলো তো স্পেশাল অ্যাসাইন থেকেই পাঠাবে সবই অ্যাসাইন নয়তো আমাদের শুধু সকালটা রাখছি এটা ওদের সময় এটা কেটে দিচ্ছি পুজো পুজো করে চলে
এটা কত হচ্ছে? 18? 18-19 take it. 18 and 19,
yes
I am for the appellants in both, but I am instructed to say that probably a terms of settlement is in the process of being prepared.
18
no.
and
18.
18.
19 and 20.
Oh, I'm sorry. I'm sorry.
একটা অর্ডার রেকর্ড করুন দিস ইজ দ্য থার্ড অকেশন after December 24 2025 and May 13 2026 when none appears for the appellants at the time of call full stop accordingly what are pending the appeal and the application
The application is being, the paper books has been filed, my lord.
accordingly APO 71 of 2021 along with ASFC 3 of 2025 are dismissed for default without any orders to cost. Interim order, if any, stands vacated. Next.
Lordship may kindly grant me leave to file my Vagalatama department, my lord. I don't
Leave
know
is
the
granted on the prayer of learned counsel for the respondents. Leave is granted to the respondents to file. Leave is granted to the learned advocate on record for the respondents to file Vakalatnama in the department. By today.
By tomorrow, kindly.
By tomorrow. Next. Yes, you're saying compromise. So when should you keep it? Tell us. We'll give you a month.
2 weeks.
2 weeks.
You're for the appellant, Mr.
Appellant.
I'm for the appellant. In both the matters.
Learned senior counsel for the appellant submits on instruction that talks of settlement are going on between the parties. Full stop. Accordingly, let the matter be listed next on August 12th, 2026 for passing further orders. 12th August.
Settlement.
No, there is no settlement.
Next.
Yes. They have approached us. My lord, there is no settlement because they have sent us a terms of settlement, my lord. We have sent to our client, but there is certain dispute. My lord, that is why they have again wrote it and send them back. I don't know, my lord, whether that will be kept or not. Because
He said talks of the settlement.
yes, talks of settlement, my lord. We
To
didn't.
go on talking, we'll keep on adjourning.
No, she won't do this. We get the settlement can be done but within a time bound period. But this
12th August you have kept it.
no. My lord said go on. That's why I took it.
We said you go on talking, we will go on adjourning.
Though you cannot
Not,
be,
we have, if we keep put it out of the list, how can we adjourn?
no.
We have to maintain the practice of adjourning matters. So we keep it in the list.
No. What do you want?
We need a clarification from this court whether this matter.
Yes, purpose has been served. Next.
My purpose is
No, his purpose.
His no, only 12th of August.
Maintenance of a beard is very costly.
That I'm found seeing now. Additional expenditure. What she was doing in some point.
Never maintained.
Never met.
Kept for some time, then it did not grow properly like you.
Like,
So that's why again
I keep
reverted back.
like me, not doing properly.
No. Yours is growing properly.
Okay.
Mine was not.
Not.
Next.
কি বললাম আমি?
এটা not to take an order record করতে হবে।
22.
Yes.
I'm opposing Miller. This is pending for some time.
Lord, I'm being led by Mr. Lord Shojit Nath Mitra, Lord. He has
They have
requested.
been taking adjournment before the learned single judge because of the pendency.
No,
Miller,
there's
last
another
occasion
appeal
it was
which has
called,
been
it was
filed.
made not today by Lordship because of that.
এটা order sheet টা দে।
No, it was made not today because it was item 17 last week. They were not there. So my lord, the list has collapsed. Before that also, my lord, going to circuit this was called. They were not there.
Lord, we have preferred an appeal from another order
Let me-
passed. On that account, we have taken adjournment, not because of this.
এটা ঠিক দিয়েছো তো? This is item 22.
Yes, ma'am.
22 দিয়েছো তো?
22 to 24 and then 26 to 27. Lord.
মাথাটা গেছে একদম।
Lord.
বোর্ড একটু দেখিয়ে দিন, শুনছেন তো? 22-24, 26 and
27.
26, 27. কমা দিন একটা, কমা নেয়, কমা। আমি ডিকটেট করে যাচ্ছি, আপনি নিন। একদম পারফেক্ট, একদম রেখে দিন, আর টাচ করবেন না। In the meantime, you get prepared from your.
No, my lord.
Anything can happen when the file comes. Even we are not sure.
In that case, my lord, can it
The
be passed
Dasgupta
to,
will dictate what will happen actually.
in that, my lord, in that regard, can it be passed to him, Lord? I'll look for him and then, Lord, I'll.
Vehemently opposing. If he opposes, we have to refuse adjournment. You get yourself prepared, mentally prepared on the facts. Do this. They'll take some time to bring them because of the volume of the. See your right hand side. That's the reason. জালি দে জলি দে বলছে পঁচিশটা জালি দে বলি করে জলি জালি পছন্দ করে জালিগুলো পরিচিত আমার কি করে নেটের সেন্স হয়ে যাবো নেট On the last two occasions, none appeared for either of the parties.
No. Last token which was made orally not today. Last Wednesday.
No, in writing.
That must be Millard.
13th May 2026, the last two recorded orders, 30th May.
I mean, thereafter it was called twice.
No,
Then,
I'm sorry. 13th May orders has been recorded twice.
yes. Thereafter, after Millard went to circuit,
One occasion it was adjourned. None appeared.
Thereafter,
After
it was,
Justice Bhattacharya release.
thereafter it was called twice. Last day also, last Wednesday it was also called. They were not the only men, not today. Then my lord,
Now we'll record, so it will be on record. On the prayer of the appellants, the matters are adjourned for the day.
this should not. My lord, they are
Lord,
taking
next week-
adjournment before the learned single just showing the pendency of this.
Lord, next week, Lord, I'll do the matter.
If your appeal is pending, you'll also do that.
But it's my lord, I am getting prejudice. The execution of 2015.
Every respondent gets prejudice when that is done. So what? They won't get an adjournment.
After this line, my lord,
One or two adjournments, yes. After that will become strict. ডাক্তার পয়েন্ট আপনি আর কি দেখছেন ওরা পাস করে দিয়েছি yes
I'm appearing on behalf of the respondent lordship. Here the appellants are not appearing from the day one, the day it has been assigned.
from the day it
Lordship-
has been assigned.
Yes, lordship,
Yes.
there was a direction to serve them. I have
Up-
given a
just let the at least the order sheet let it come. After assignment, it was taken up 24th December 2025. When you appeared, they had not. Then it was taken up on March 13, 2026, when none of you had appeared.
13th
May, sorry,
13th May. 13 May, yes, lordship.
So they get another chance. Although the respondents are represented through counsel, none appears for the appellant at the time of call. Accordingly, let the matter stand adjourned for the day. Next, not today. No order recorded.
Lordship, do I serve them again once more?
You can do it. You are not directing. You can do that. It will help you on the next occasion if it is called on at all.
My lord,
Yes.
my lord, 29, I appear for the respondent.
Respondent, we are not interested in respondent. Where is the appellant? Bring your appellant. Mr. Sinha is for the appellant. We are appointing him as amicus. So we are making it not today. Mr. People did not expect, obviously, because of the ongoing hearing matter.
Right.
First few matters we made not today, but after that, yes.
Look, we are for the appellant out here.
Who told you to appear?
Also, my lord, this is also, my lord, another appeal, my lord.
Yes.
That has just been released. My lord, from the same order, there were two
It
appeals.
has to be assigned first.
It has to come before you. Another one. has
Unless
to
it is
come.
assigned, we cannot direct it to
Yes.
appear before us.
So, my lord, in that case, my lord, kindly keeps it, my lord, after, my lord,
After what?
fortnight, my lord, then by that point of time, it should come before you.
Yes, Mr. Sinha, strongly opposed, refused.
No, my lord, he's. I am one of the silent respondents.
So 12th of August, we are putting it 2 weeks after.
Very well.
You are for the appellant.
Yes.
Yes.
Then counsel for the appellant submits that that a connected matter
I'm an appeal to the ballot.
we cannot say.
It has been released.
We're not recording any order.
Very
Just making it not this week.
Yes.
In any event, if the previous matters are called on next week, then we cannot.
The lordship is not fixing it on 12th of August.
No. We are just making it not today without recording anything because we can't record that a different bench has released and we expect it will be assigned to us.
But your lordship can fix it on 12th of August by this time, by it will
It makes
come.
it a fortnight.
You're for the respondent.
One of the respondents.
So on prayer of both parties, we are doing that then.
Yes, my lord. He's not the main respondent, so my lord, that's why I'm saying, my lord.
Your respondent number?
Number 4.
Although the appellants and the respondent number 4 are represented through counsel, none appears for the other respondents. Full stop. On the prayer of the appearing counsel, let the matter stand adjourned till August 12, 2026.
Much of that.
Not today. No order. Same. You are appearing? 32. Well, it's we are appearing. Yes. Fine.
That's good.
Give us half an hour to bring the file.
Yes.
No, no, not half an hour, please. ফাইলটা দাও, করবে ওরা। ওরা ওরম ভাবে তাকাচ্ছে, কি আসছে? ইউ রেডি ইন দ্য ম্যাটার? করবে বলছে, তুমি ওদের দিকে তাকাচ্ছ কটমট করে। কটমট করে তাকাচ্ছে যে না করে, কেন কি করতে বলেছে?
আমার তো মনে নেই।
এটার পেপার লাগবে, শুধু অর্ডার শিট দিলে হবে না। দাও দাও। Yes, what is the matter about it?
I'll just tell your lordship in brief.
Samitra, you can take your seat, we'll just see.
Well, it's order 7, rule 11, I had filed. I'm appearing for the defendant, Malaj.
Rejected.
It's rejected. I've come up in appeal against that, Malaj. I tell your lordship in brief what has transpired over here. The plaintiff company is a shareholder in respect of the defendant number 6. And he has a shareholding of approximately 7.9% shares in the defendant company. The defendant number 6, Malaj, is a...
You are the defendant number 6.
No, Malaj, I'm not the defendant number 6. I tell your lordship, I'm the auction purchaser of an asset which was owned by the defendant number 6.
So you filed the 711.
I filed the 711 because I purchased the property, Malaj, in lieu of a SARFACI in lieu of the proceedings under the RDDB-FI Act, saying that there was a bar-in-law under Order 7, Rule 11D. Malaj, other than that also, Malaj, there are other points that I will perhaps agitate in appeal. This was not agitated before the single judge, Malaj. I'll be very candid. But the point of Section 430 of the Companies Act as well, I would want to agitate by saying that 7.9% shareholding is perhaps an indirect way of coming to your lordship, alleging operation mismanagement against a target company and preferring a suit before the learned single judge.
What was the suit for? The print?
But the suit was for declaration, delivery up and cancellation, and declaration of right title and consequential relief, and for delivery up and cancellation as well, Malaj.
This cannot be granted. You can.
বাকি পেপারস গুলো আসছে? আছে তো? ঠিক আছে। এখানে তো পেপার বুকের ব্যাপার নেই, তাহলে দিয়ে দাও ওগুলো।
2 supplementary affidavits have also been filed. Stay.
সব পরে ধরে বসিয়ে দাও। Yes.
But we are also, I'll just surprise the lordship, we're also enjoying a stay over the suit at the moment. And with the leave of the court, Malad coordinated benches of this court, supplementary affidavits were also filed to demonstrate that certain deeds had been,
Can you go beyond the plaint or the documents referred to the plaint?
Perhaps not, but there's only one aspect, perhaps I will try to, your lordship may test me on it. But the reason why perhaps the learned coordinate bench also granted us that leave to file a supplementary affidavit with the deeds is to see whether the suit is vexatious and whether it's an abusive process. But as for that, perhaps your lordship can go outside the plaint.
All right.
Insofar as the bar-in-law is considered, I understand your lordship will be bound by the averments made in the plaint itself. Malaj will kindly appreciate. So the defendant number 1, Malaj, is the owner of a suit property which is situated at Old China Bazaar Road. The defendant number 1 is the successor in interest of a company known as Gaylord Trading Private Limited. And it is pursuant to this amalgamation that between Gaylord and the defendant number 1, that defendant number 1 became the owner of the property. Well, I'm sorry, Malaj, this is defendant number 6. The defendant number 6 was amalgamated, not the defendant number 1. I'm sorry.
Give us the name of defendant number 6. I will check up.
Yes, Malaj. Malaj, can you just give me one moment, Malaj? I'll just...
Yes. Chandan Construction.
Yes, Chandan Construction.
This is the petition, volume 1. You have annexures over here, and then we'll come.
You are for Chandan and Mr. Trivedi is for construction.
No, Millard, actually, Millard, what I apologize, Millard, because I normally have, Millard, because I was to ascertain, Millard, whether I can do matters which is per se between 2 private parties. Now, Millard, that unless I don't ascertain that, Millard, I cannot lead in a matter. Yesterday, Millard, also the same problem I was faking, because these are civil suits, Millard. Arguably, Millard, I can be, because it has nothing to do with state or center. It is...
What is it difficult?
Millard, but I need some clarification. Therefore, I am there, Millard. But Millard, I am asking, Millard.
Can't lead, then you can't also follow.
Millard, I cannot follow, Millard. But as of now, Millard, I don't.
Why are you here wasting time? Your time, not ours.
Millard, it is a pleasure to appear for Millard, because this is basically what I want to do, something which is very interesting and intriguing to me, Millard. Order 7, Rule 11, Millard. That also, Millard. In a particular, Millard, the property, Millard. I just, Millard. I would intend to address for Ms. Millard. Millard, the basic crux is, Millard, what we said is, Millard, that the plaint, the prayers which are contained in the plaint, it is with regard to setting aside in a circumvent manner a sale which was conducted by Debt Recovery Tribunal. I got a sales certificate from there, and the relief can be granted by the Debt Recovery Tribunal. Now, Lordship, in this particular plaint, they have challenged that sale, which they could not have done. Because what they cannot achieve directly, they cannot achieve indirectly. This was my first parameter. Then, we were on cause of action. That whether they have any cause of action, because admittedly, Lordship, this particular plaint...
The plaint disclosed any cause of action.
I stand correct. Lordship, plaintiff says that he has 7.9% share.
7.97%.
9% share.
So is it a bar under section 34 of the SARFAESI?
Lordship, it is. No, I'm not going to SARFAESI, Lordship. What I on another point, I will cite judgments.
The first one, bar.
The first part, yes, Lordship. There is a bar. If my lords kindly see,
this is a different act.
Yes, it's a different. RDDB Act. It's RDDB Act. That is recovery. Lordship, it's recovery of debt due to Bank and Financial Institution Act.
What section is that? The bar.
That's section E.
I mean, Lordship will kindly see that is
18.
Section 18, Lordship.
Part to civil
that is RDDBFI Act, which full form, Lordship, stands as recovery of debt due to bank and financial institutions. Now, Millard, we have pleaded, Millard, that as far as the prayers are concerned, Millard, there is a specific bar under section 18 as well as section 20. Section 20 gives a right to appeal regarding to sale. Now, the crux of the matter is, Lordship, if I take my lords to the plaint, my lords, I will try to bring it to my lords.
Page 34 of the application.
That the prayer which is contained, it actually is directed at setting aside the sale, which can be done only by DRT because there are two.
The sale was under the trappings of that act.
Yes.
So that is the legal word.
That is the legal part.
And this non-disclosure of cause of action?
Non-disclosure of cause of action, because they have admittedly stated, Lordship will kindly... They claim their right, Lordship, from a shareholding in respect of the defendant number 6, which is to the tune of 7.9, where admittedly, Lordship, the sales certificates also were not transferred in their name.
Yes.
Then they say the company also was struck out of the list, and during pendency of the suit, they got the company again resurrected.
Which company?
This respondent number 6 company. Plaintiff is saying that
defendant number 6 company.
Lordship.
That's the target company who owns the asset.
Yes. Because that is...
This is went into liquidation.
Lordship, no, Lordship, this respondent number 6.
Struck off the...
Respondent number 6 had this particular property, which was sold to me.
That we've understood by now.
Now, Lordship, 9.7% shareholding of that company
was with the plaintiff.
With the plaintiff.
You say those shares were never transferred. So they did not have that shareholding in the first place.
My lord, they maybe, that company came as amalgamation. So, my lord, they say that by that amalgamation, I got that 9.7% share.
If they say that in the plaint,
yes, my lord.
We cannot say.
No, I'm not saying, but a question I'm putting to myself is, my lord, 9.7. There are judgments which I will cite before your lordship. 9.7%, my lord.
Yes.
Whether they have, and the company has sold that particular property. That company had taken loan. Now that company taken loan, SARFAESI proceedings were drawn against that company. The property was sold in a court sale by DRT. Now, a person having 9.7% shareholding in a company could have had any right to oppose to that sale where the company, through their major shareholders, had taken loan from a particular financial institution, and then SARFAESI proceeding was drawn.
So you're on prima facie locus standi,
yes.
Rather ex facie locus standi.
Yes.
And 7.97%.
And 7.
It stood in the name of the erstwhile company.
And 7.59% stood in the erstwhile company. The names were also not. The company which was amalgamated, Lordship. It's slightly confusing, Millard. Will kindly not take me amiss, Millard. Now, Millard, so Millard, my contention before your Lordship.
9.7.9.
A list of date would be required, Millard.
7.9, Mr. Mantha can make that limited argument on 7.9 and then you come back. Yes, Mr. Mantha on the second 7.9. Only on the 7.9, yes.
But
Quick.
only in
Yes.
respect of the 7.9% shareholding, the submission is the share certificates record the names of the erstwhile owners of the property,
Gillot.
erstwhile shareholders.
Gillot.
Yes. So till such time that the shareholding name, the name in the shareholding is transferred, Malats, I'll be relying on Middleton Hotel's judgment. The only right that the plaintiff had was to have his name incorporated in the share certificates. This is in respect of Rule 11A, Malats. My point of cause of action. Lack of cause of action. So the plaintiff, my lads, didn't even have the right to agitate the suit. And my lads, the prayers naturally, insofar as the bar-in-law is concerned, my lads, my revered senior is making submissions to that effect. But insofar as the 7.97...
So therefore, it's a two-phase bar,
Yes.
two-phase lack of locus standi. One is that their right for the present is only restricted to incorporate their names, get their names incorporated in the records in respect of those shares.
Yes, yes.
So it's an inquiry right insofar as the companies, the
Yes.
share is, the
Yes.
shares are concerned. Secondly, even if they had the shares, it's questionable how far they would have locus standi to resist,
Yes.
because the borrower was the company in which they had shares.
Okay.
And so it's, I mean, tertiary connection.
Correct. And my lads will kindly appreciate under section 20 of the RDDB Act, they have a right of appeal. It says any person...
That was argued in the bar of law.
Yes,
Section
that was
80
argued in
civil
the bar
code
of-
bar and section 20
Yes.
appeal provision.
Well, at 7.97%, there'll be another point that I'll perhaps argue. I didn't take this up before the learned single judge, Malas, is that this is perhaps a way to circumvent the Bar and the Companies Act as well. Because today, what they are alleging in their plaint is
So
that,
mismanagement and operation.
yes, they are essentially alleging mismanagement and oppression. That the affairs, which is why it came to be struck off, they're essentially alleging that the affairs of the company were not managed properly. So there's a bar under the Companies Act under 430, if I take the pleadings to be true and correct. Now, they, Malas, have made averments in respect of fraud. Now, Malas, I'll also try to demonstrate to your lordship by placing those averments and the annexures to the plaint that the pleadings insofar as fraud are concerned are also illusory in nature.
So that is on Arvind Nandam.
Yes, Malas, and T. Arvind Nandam, Malas. Malas, and thereafter, Electro Steel's judgment also, Malas, in the more recent one, which considers this
Fraud is illusory in what sense? If fraud has been alleged, but there is no substantiating pleading.
I tell your lordship, it's
Undervalued.
valuation, Malas.
Undervalued.
They have said, Malas, that the transaction pursuant to which I acquired the property by way of the sale conducted by the Debt Recovery Tribunal was severely undervalued. In order to substantiate that, Malas,
Allegation is this.
yes,
They're
Malas.
under only allegation.
Malas will kindly note, Malas, subparagraph 12
Of the plaintiff is at page 53 of the first volume.
Yes, Malas. Will,
Where the fraud has been.
Subparagraph Roman 12.
yes, Malas. Roman 12, Malas, of paragraph number 40.
So this
Malas,
is of
sorry,
the-
I apologize, Malas. Paragraph 40, Malas. But yeah, particulars of fraud have been given. Subparagraph 12, Malas, is perhaps one of the main points of fraud that they've alleged, which is the undervaluation of the transaction. But if I may just place what their averment is to that extent, that the said property was sold in a purported public auction only for rupees 2 crores.
But they can either say which volume. Volume 1, page 53.
Yes, got it.
Yes,
53.
Page 53, Malas. Malas, Roman 12, Malas.
Yes,
That-
yes, Sharad.
Yes. That the said property was sold in a purported public auction only rupees 2 crores as against the real value of the said property, even if tenanted is rupees 20 crores, clearly goes to show that the public auction was charade and got up and transferred to defendant number 1 was a part of a fraudulent scheme hatched by the defendant numbers 4 and 5 in collusion with others to have the said property transferred from the company behind the back of the other shareholders and essentially the plaintiff in such manner that the ultimate transferee reaps the actual profit by way of developing the said property. Lordship will also appreciate that none of the other shareholders have come forward, Malas, alleging any challenge to the instant suit. Malas will kindly take page numbers 73 once, Malas. These are the share certificate. I'll just place those documents. Lordship will kindly, Malas, forgive me for being a little haphazard here. Well, it's page 73, my lords. This is a part of their plaint.
Yes.
Well, page 73 onwards, your lordship will find share certificates that have been annexed all the way up to page number 88.
Hmm.
And your lordship will find, my lords, all of them are in the name of Gaylord Trading Company Private Limited.
So that's in support of your the
Yes.
second argument. Yes.
That is in support of the second ground.
Right.
Now, my lord, insofar as the valuation is concerned, my lords, they annex a valuation report to the plaint.
You start. I'm assisting.
My lords, they've annexed a valuation report.
So either of you may argue, Mr. Trivedi. You may also argue.
No, Millard, Millard, let him argue, Millard. I'm just assisting because, Millard, as far as pagination is concerned, Millard, I will be very candid.
Whatever. One of you
Millard,
argue.
let him argue, Millard. I don't want to break.
Very well, understood. Yes.
This kindly gives me a moment, Malas. I'll just show that valuation report that has been annexed. Because the valuation, Malas, my submission is essentially that the valuation that they annex to the report is significantly prior to the actual sale. So the undervalued transaction that they are alleging, Malas, of the value of the property being 2 crores is as on the date of filing
Has
of
to be
the suit.
contemporaneous.
Yes.
The valuation report had to be contemporaneous. But
Malas.
that is a subject matter of trial. They can prove it otherwise also.
No, Malas, my submission is that if today they are saying that the transaction is undervalued, well, at least they need to demonstrate that it was undervalued as on the date of the sale taking place.
Mr. Mantha, suppose that document is irrelevant, not German. The document which they've annexed. Still, pleadings need not incorporate proof. Evidence need not be pleaded.
Yes, Manoj.
So they have alleged that. They have to prove that in trial. So at this stage, it would be rather premature to hold that that fraud is illusory.
Well, the reason I say this is that if there is a pleading, well, as insofar as substantiating it in trial also, well,
Because we're at the Order 7 Rule 11 stage. We cannot prejudge the suit.
But I bow down. Manoj.
Whatever way they can prove it, you can disprove it or you can say it was not proved.
Well, but if the document, well, I ask myself this question.
Yes.
If the document that they rely upon to demonstrate
Suppose
this,
that is irrelevant. That does not cut ice. That document is not taken as a proof of their pleading. Nothing prevents them from bringing other documents on record in the evidence when they adduce evidence.
Well, I bow down, Manoj.
Suppose this, even if we take it from you, the document annexed to the plaint in support of that pleading is not German or is not relevant at all. They can prove it by other evidence also at the time.
They can. Manoj, I bow down to that.
7-11, it's very difficult to get an order on that ground.
But that is why, Malaj, I'm saying that this case, Malaj, may be viewed cohesively and not just merely on that one point. Because, Malaj, if I'm saying fraud is illusory in nature, today I'm trying to also demonstrate the conduct which is made out by the plain case itself. That today I come forward before the suit court challenging a sale, and in order to demonstrate that the sale is bad in law, with my limited shareholding, I am relying upon a report or a valuation report which significantly predates the actual sale. In that event, Malaj, I ask myself whether your lordships, even in 7-11, would consider that the pleading of fraud vis-a-vis that report, Malaj, is perhaps illusory. When all facts are viewed together.
All right.
But that is at least on so far as the point of illusory cause of action is concerned. Whereas these are the 2 points also insofar as bar and law concerned, Section 430 of the Companies Act, because of the limited shareholding, and the fact, Malas, that they had a right of appeal under Section 20 of the RDDB Act, and there's a bar in law, Malas, in terms of Section 18 thereof. Whereas this is the sum and substance of the case, Malas. Perhaps
any judgment you want to cite?
Malas, there are some. Malas, maybe come back with the written notes along with all the judgments, Malas.
Yes, we'll hear oral arguments today. And written notes, both of you come.
So not my oral argument, my lord. For me, I'm open. I'll look into this, but tomorrow I'll get ready. The brief is here, no doubt, but I'll get ready by tomorrow.
The lordships are taking up original side matters every Wednesday.
Every Wednesday.
So your lordship can kindly keep this, Malas, some preference.
No, this will now be parted, goes to the bottom of the parted list.
Okay, yeah. তাই চলে যাবে, ঠিক আছে।
Your lordship kindly doesn't do that, my lord.
No, bottom of the part-head list. Part-head list is at the top.
একদম উপর দিকে থাকে।
The other part-head matters are already there.
I'm great. I'm sorry.
তিন চারটে pattern।
Well, these supplementary affidavits may be taken on record because it was pursuant to leave granted. হ্যাঁ, সব দেওয়া হয়েছে, তুমি সব দাও।
On the basis of
supplementary affidavit.
we've also filed an amendment to the plaint which is pending. Because new facts have come in by way of
Amendment application is not here.
That is pending.
There.
Well, may these
Fair. The supplemented affidavit filed by the appellant today be kept on record, full stop, heard in part. For further hearing, list the matter on July 29, 2026.
Well, we'll come with notes also ready on the next day.
We are not requesting you to do that right now because after their argument, you may have to add something. So we can prepare the framework of that, but don't make it conclusive. Don't file it on the next day.
No, my lord.
Wait
We
for them,
will not.
what arguments they make.
I'm grateful, Lord. Thank you.
Grateful, Manoj. Thank you.
Sincere apologies, Millard.
What will you do if you refuse the apology?
Man proposes, God disposes.
No, we can just penalize.
That was very well
That
said,
was
my
very
lord.
nice.
That was not only very well said, very.
Millard, I have no sarcasm. Millard, not take me. There's no sarcasm.
No, we can penalize you by recording your name today. That is the
Millard,
worst we can do.
because Millard, as far as
And we'll refer to you as DSG, learned DSG,
no, Millard.
and record your name. That will
Millard may record my name, but Millard, because the only
we can
problem.
refer to you in our order as learned DSG submits so and so, such and such, and we can add that before it.
Millard, that is because Millard.
দিল্লিতে no AGs can appear.
নেই in private না কর আমিও করব কিন্তু প্রাইভেট ম্যাটারসে করতে পারবো
No, the same principle which applies to the state should also apply up.
I know in New Delhi, in Supreme Court, AGs can't appear. Private
My
matters
lord, what has happened is Millard,
Appear.
they don't appear. They can't appear. In private matters also.
Millard, as far as
They-
therefore Millard,
Because they
therefore
have
Millard,
given undertaking, then I will not appear in private matters
Be
also.
careful with the slip then.
yes, Millard, as far as I
the slip, be careful with that.
मत दो because Millard, what I have ascertained, Millard, as far as 1, 2,
Vikramjit Banerjee, I asked him.
so as far as Millard,
I can't appear.
as far as Millard, Honorable Supreme Court
There's
is
a different paradigm here.
Maybe.
Yes,
If
Millard,
it otherwise is good. But if the same thing applies here also, then ASG can't appear.
Millard, that's why I want a clarification.
Sorry,
but
DSG. DSG.
Millard, I was 4.5 years, I was DSG, so I myself am referring myself as DSG because that has not, this new word has not synced in yet. Millard, it's only 1 week. So therefore, Millard, I'm cutting a sorry figure before my
You decide whether your name should be recorded.
My- my-
Should be, why not? You're appearing. Put it. Yes.
रख दो फिर उसके बाद सब देख लेंगे।
And build the center for this.
My lord.
Call code. 33. Why are you looking embarrassed, Mr. Datt? You appear to be ready in the matter, but
For the respondent,
you're for the respondent.
I'm led by Mr. Banerjee. He's on the way.
Which Mr. Banerjee?
Shauradipta Banerjee.
Pardon?
Shauradipta Banerjee.
He'll be coming.
Yes.
Yes, Mr. Datt, what do you start? Yes.
Millard, kindly take Millard, volume 7. Volume 7. Paper book koi?
Actually, volume 6
Paper book দাও, volume
wrongly
7.
printed.
Your lordship has the impugned order.
Yes, we can start from there. We are thinking.
Millard, it's the order, Millard, by which your lordship will find 1, 2, 3, 4, 7 or 8 applications have been disposed of. Judgment is of 10th of October 2024. Issue is this. Millard, this arises out of a testamentary proceeding. 2 daughters of the testator. Will has been made, equally given, will probated on consent by this honorable court. Dispute starts after, and all these applications, Millard,
On consent.
on consent. In fact, Millard, after the probate was granted, Millard, the executor has a time frame for the purpose of filing accounts. Now, my lord, my understanding of the law is that accounts is whatever is available in the hands of the executor. My lord, he has to file an account that this is what. Disputes arises in this case is regarding the division of that.
Executor was a third person, not any of
Executor was one of the daughters.
you or them.
Me. Now, my lord,
Paperbook আসেনি? Paperbooks are filed in the department
No, paperwork was.
where they were filed.
Yes.
When?
Last day also.
In court, it was not filed. At least before us, then we would have recorded.
No.
No, it was not filed in court before us, at least. Huh? Department তো হয় আমরা original side কখন
let us ascertain this and come back.
No, in the meantime, you can.
Millard, I have 2 points to argue.
Yes.
One point is this, Millard, my understanding of the law is this, that once a probate is granted, the probate court is denuded of its jurisdiction to go into private disputes between the parties. Here, Millard, whatever was available has been divided. But Millard, before the process, it could be divided, Millard. At least 4 or 5 applications were filed by my sister, asking for accounts, asking for fixed deposit particulars, appointing auditors to examine the accounts. So basically, the crux is that she is disputing the distribution. And I'm told, Millard, a suit for partition is also pending in respect of some properties in Bombay. Now, my first submission is that the learned judge, Millard, has gone into these disputes in a probate proceedings and has, Millard, disallowed certain expenses from the accounts that I have submitted. This, the learned judge says, Millard, upon considering one of the audit reports, says that I am disallowing these accounts because these are something which you will not get. The executor will not get. Millard, he says that you have been unable to prove these expenses. When the fact remains, Millard, I was not given an opportunity to prove this. If, Millard, is at all it's a dispute, and assuming that the probate court could go into this, Millard, then at least, Millard, I should be given an opportunity to at least show that I have made these expenses. Millard, if your lordship kindly comes straight to, Millard, paragraph 35 of the impugned judgment.
So it was not on principle that you are not entitled to this, on the basis that you failed to prove it.
Yes.
Not that you are not entitled to get these expenses.
No, Millard, kindly
let us see this.
Paragraph 35, 34, if I may start with.
30.
Yes.
This court has taken into consideration both the audit reports together. So, Millard, auditors were also appointed.
Yes.
As per the balance sheet of A.K. Burman and Associates, the executrix has received a total sum of 2,44,56,817 on closure of various accounts, and the total expenditure is shown as 70,43,362.57. These are the expenses. Documents relating to telephone charges of Mumbai flats and Kolkata flats are appearing at 71 to 144 of the audit report, which reveals that the bills are in the name of the executrix, and thus she is not entitled to claim the amount of such and such and such and such from the estate of the deceased. This is an adjudication. The executrix also claimed
telephone charges. Why should you be entitled?
Millard, thing is this, Millard, this executrix is probably in Bombay.
Yes.
Millard, what the major thing is this, Millard, the 37. Oh, she's abroad. She stays abroad. Both of them stay abroad. Executor also claimed an amount of 24 cleaning expenses, so and so for filter expenses, gas expenses, but this court did not find any document that the expenditure is with regard to the estate of the deceased. The executor claimed maintenance, repair charges of Mumbai and Kolkata flats, but the distribution of flats have been settled between the parties and have taken their respective possession. That the question of charges for repair and maintenance of the flats cannot be taken into consideration. But what happens to the charges which I have done prior to the division? I am to maintain the property as an executor. Executrix has shown, this is very embarrassing, has shown professional fees of such and such, of so and so and so, and I'm not taking the names, and others connecting documents are appearing at such and such of the audit report from pages 229. It reveals that an amount of so and so is paid to so and so, and the other invoices does not match with the details mentioned in page 20 of the report. It does not reveal that the said professional of so and so is connected with the estate. The professional fees I won't be entitled to. Executed has shown
No,
travel.
this professional expenses for conducting the probate proceeding.
Millard, then Millard.
This is an advocate firm. Yes. Yes.
Executed has shown traveling expenses of alcohol conveyances and food beverages, which are also not acceptable to this court to allow the said amount from the estate. This court has not accepted the expenses from the account of the estate, as the executive had knowledge that there are so many expenses already made by the executrix in the present case, and enjoying the traveling from abroad to India and within India instead of.
No, it's a chartered accountant firm, sir.
That is there. Legal expenses are also there.
The same firm acts as a firm of lawyers and a chartered accountant firm. It cannot be. Same firm name is given. Next page is, it also does not reveal that the state professional fees of.
Oh, sorry, I'm sorry, Millard.
Chartered accountant.
But there is another dispute regarding lawyers' fees also, Millard. Be that as it may, Millard, may I just place
Yes,
it?
you can carry on. Yes.
This court has not accepted the expenses from the account of the estate, as the executrix had knowledge that there are so many expenses already made by the executrix in the present case, and enjoying the traveling from abroad to India and within India instead of settling the issues with respect to the entitlement of it. This also did not find genuineness in the expenses. So expenses are not disputed. Question is whether they are genuine expenses. Millard, I may ask myself this question, Millard. If it is a question of genuineness, that means that I have deducted money or taken money from the estate, the expense is admitted.
No, also does not find genuineness. Court says this court has not accepted the said expenses from the account of the estate, as the executrix had knowledge that there are so many expenses already made by the executives in the present case, and enjoying the traveling from abroad. Yes.
Millard, the crux of the matter is this, Millard, as I said, and there are other expenses. Then, Millard, the 43 is the conclusion. Considering the total expenses of such and such, an amount of such and such is required to be deducted. If the said amount is deducted, the total expenditure would come to such and such. The amount of 35 is to be deducted from 2 crore 44 and come to 2 crore 8. The beneficiary has withdrawn an amount of 27, and as per the order passed by this court, an amount of 10 lakhs is transferred by the executive account of the beneficiary, and thus the total amount of such and such has been received by the beneficiary. The total amount of 37 lakhs is also to be deducted from 208 and would come to 1. Then, Millard, it's mathematics, which also I'd show is incorrect.
No, chartered accountant firm was engaged by the court, appointed by the court.
One. And Millard,
that was different chartered accountant. Chandan.
There were two audit reports. There were two audit reports.
So what was the requirement of having an audit report from the other firm?
Millard, the other report, one Millard, this chartered accountant, Millard, so far as one or Millard, he did not ask for any documents from me. He just went on with the audit report. So I filed an exception, and along with the exception, I also filed a report of the chartered accountant, an audited accountant, chartered accountant. Now, Millard, bereft of all these issues, Millard, what I'm trying to understand is, after a probate is granted, the estate is handed over to the executor for distribution.
That is the first point.
Now, Millard, if my learned friend disputes that this amount of deductions made from the estate, he is not entitled to bear the same, Millard. That becomes a risk between two individual parties who have got the estate. Now the question is, does the power of the probate court extend to that extent, or does it leave the parties to sort out their grievance before an appropriate forum?
So distribution of assets till that state, the probate court, you say, doesn't have the power. Once you grant probate, it's over for the probate court.
Obviously, Millard, once grant probate, it's over. Thereafter, the duty of the executor is to.
That's a duty cast under the statute on the executor. That will be the subject matter of other litigation.
Yes, if the executor doesn't put it, that gives my learned friend a cause of action to sue for revocation. One of the grounds for revoking the grant is that executor has not filed it. But Millard, it's a dispute which has arisen. That would be my first point. And the second point is this, Millard. So far as these entitlements are concerned.
But you had filed these applications before this.
No, learned friend. One of them or two of them are of mine. The rest are all my learned friends' applications.
What were their applications? You asked for those amounts. You are the
Milord,
executive.
I two application, one was taking an exception to the audit report, which was filed at the instance of, and Milord, another application by which my audit report has gone in, right? Those are the.
No, you are the executrix.
Yes, Milord, I am the executrix.
So they applied, their applications were challenging the inclusion of this amount.
Various, from
It
time
was-
to time, various acts of the executive.
including this inclusion of these heads. So their applications were allowed.
Milord,
I mean, disposed of.
expressly, Milord, if your lordship comes to, it's been disposed of. The rate at GA3, GA6, GA7.
So therefore, these the learned single judge only disposed of. I mean, they disallowed these components of the account. That was the only order passed.
Only order passed.
No other prayer was granted to either party.
That obviously with the direction to pay.
Yes, yes,
Yes, that's a consequence.
That is a
That's
consequence.
consequence. Milord, I will now need to go to the paper book, Milord. The reason why I started, I'll be very candid, I want to be in the part hard list, Milord.
Really. Oi, hard in part. List the matter for further hearing on July 29, 2026.
Fine. পেপার বুক গুলো আনি
হ্যাঁ কি at the top থাকবে
না না
পাঠার লিস্টে থাকবে
পরে আমি
পাঠার
খুঁজে
লিস্টে
রেখে দেন।
পুরোটা বেশি।
22
একটু বড় নেই এখন ইয়ে করো না এটা বেরিয়ে যাবে পাঠা ডনের সাথে মেটাল রয়েছে
Oh, bless you.
Thank you.
I appear on behalf of the respondents.
You are making not today, just they are not there. Not.
35 not I appear.
Yes. আগেরটা রেকর্ড করতে হবে না আগেরটা quota of the parted list, Mr. Cod, is finished.
But this is section 5 application and a section 37 appeal. Lord,
Section 5 has been dismissed.
No, this is the appeal.
Here before us. Oh, section 37 is. What is the delay, Mr. Cod?
Delay is to the extent of 1100 and odd days. Out of which, Lord, if the COVID time is taken out, it will come down to about roughly 800. There is enormous delay. I must tell your lordship that there is enormous delay. I can't get out of it. And in fact, originally, when the petition was filed, the section 5 application was filed, then, Lord, there was hardly any explanation. So, Lord, I took leave of your lordships to file a supplementary affidavit. Lord, keeping in
GA টা দাওনি তো সেকশন 5 টা শুনানি হচ্ছে তুমি
DA1.
GA সাপ্লিমেন্টারি যদি থাকে সেটাও দাও
And to that,
এই তো
there
হচ্ছে
is an opposition. To this, there
সেকশন
is
5
an-
তো GA টাই তো আসবে
Lord, may I file the supplementary affidavit because they have used an opposition to both the application.
You file your opposition then also.
You have filed an objection to the supplementary
They
affidavit.
have already.
Oh, you have already.
Yes, there is no reply.
No, did you file it in court? আছে opposition দেখি opposition. This opposition is to the supplementary affidavit only, not to the section 5.
Section 5 also opposition 5. But there is no reply to that. as well.
পিসমিল দেবে নাকি বারবার জিজ্ঞেস
Section
চাইছি তো সব কথা।
separately going to section 5 is separately
নেই,
affidavit. gonna file.
it's not on record.
No, no, section 5, I don't think they filed any affidavit separately. They have only filed an opposition to the supplementary.
Supplementary affidavit.
Because, Lord, perhaps
Supplementary contains the crux of it.
the crux of the matter.
That's why it was recorded in the first place.
That there is no dispute to that. because-
Supplementary affidavit to section 5 is always for that.
Lord, I tell you, Lordship, when I saw the petition, there was a paragraph, Lord, there is only one paragraph because, Lord, this is on the original site, Lord. We don't file separate application. It is in the same application we plead. Then I found that the pleading was insufficient. Therefore, Lord, I took leave to file the supplementary affidavit. If your Lordship kindly, Lord,
May I just give your lordship, my lord, the two dates? The order was passed, my lord, on 14th of July 2023. 14 July 2023.
31 of the state.
This is, my lord,
The section 34 award was passed. Section 34 judgment was passed.
Section 34, my lord, challenging the award was dismissed. The crux of the matter is that there was a point of limitation which was taken. This was not sustained before the learned single judge dealing with Section 34 application. Now, my lord,
So you took a point of limitation.
yes, Lord, we said that, no, I tell your lordship, Lord, why?
Yes.
Because, Lord, there were three parts of the claim. Originally, the claimant had filed a suit. That suit, Lord, was referred to arbitration under Section 8. Now, Lord, beyond the suit, whatever claim in the suit is, that was their claim B. Claim A was something which they added, which was not there in the suit. And claim C was the interest on both, Lord, claim A and claim B. So, Lord, with regard to claim A, Lord, the point of limitation was taken. And, Lord, if he succeeded on claim A, then, Lord, the interest will also...
Interest component on claim A would go, but B would remain.
B would remain. B would remain. Now, Lord...
and this is that arbitration
no,
agreement taken.
ठीक है.
This was the claim.
So B on merits you did not challenge.
B on merits, Lord, we did not challenge. Our restricted challenge was that so far as claim A is concerned,
A time bar, it along with its interest should go.
Now, Lord, the Section 34 was dismissed. From that, Lord, Section 37 we had filed. Now, Lord, if your lordship kindly take the supplementary affidavit.
Yes.
The explanation starts from paragraph 4, page 2. Lord, I must tell your lordship, instead of, Lord, placing the paragraphs, Lord, the matter, Lord, was dealt with by the Planning and Development Department. There was a tender for renovation of some underground reservoirs of the Calcutta Municipal Corporation. And, Lord, the work which was done, that is the subject matter, Lord, of dispute, because, Lord, so far as their running bill number 1 was paid, the other 2 running bills remained outstanding. That's the basic dispute. And, Lord, the other claims which came, Lord, in before the arbitrator, those were not the subject matter of the suit. The subject matter of the suit was the non-payment of these 2 bills. Now, Lord, the matter related to Planning and Development Department, and there was a gentleman, Lord, who was dealing with it. When the judgment, the award came, Lord, the order came, then, Lord, the matter was referred to him. That is, Lord, paragraph 4A. Your lordships will find, Lord, the matter was referred to him, but unfortunately, Lord, he was transferred. 14 July, Lord, he was transferred. This transfer order, Lord, is there.
14 July is also the date of the impugned judgment.
14, no, impugned order was passed. I'll give the lordship.
Give that date.
Yes, that day itself, his transfer took place. Lord,
yes.
No, sorry. His transfer took place on 17th August. I am wrong. 17th August, 14 July, the order was communicated.
Yes.
Then 17th August, Lord, he was transferred.
Right.
This transfer order and other documents are all, Lord, annexed to the application. Then, Lord, what happened was, post-transfer, the gentleman who joined, he had no experience in the arbitration matter. He came from the municipal court. This was, Lord, the transfer. Your lordships will find. And sufficient delay, Lord, happened during this period. Between 14 July 2023.
In E, you say he was acquainted with the type of matters being dealt with.
Not, it should be not, because he was posted.
Just sentences.
Yes, absolutely, Lord. That not is missing. There are many typographical errors. This is a serious.
No becomes yes is very crucial. Anyway.
So, Lord, this is what happened. Then, Lord, then he he in December 2023, my lord, he attended to the matter. Then, my lord, he entrusted the matter. There was some departmental, my lord, issues. Paragraph H, your lordships will find that. He took refuge, my lord, he forwarded the matter to the municipal law officer. And then, Lord, there was a decision taken to prefer an appeal. That was on 12th of January 2024. And ultimately, Lord, the matter was referred to the learned advocate, and Lord, ultimately the draft prepared. It was filed.
Mr. Sanjay Das's non-acquaintance with arbitration matters, how does it
No, Lord, what
matter?
happened was that the time limit, that there is a time limit to act on the basis of the order, that unfortunately slipped his mind, and he was not acquainted with the dealing with these matters. So therefore, Lord, I tell your lordship, this is the true fact that I had placed, Lord, in the paragraph.
He's appointed as a law officer.
He's appointed as
Can
a
I
law.
take that plea?
No, it's that, Lord, he was placed in the municipal building traffic.
You are not clear. Your government is not clear on whether he had knowledge of the award.
Lord,
You have clearly said he did not have acquaintance with arbitration law.
Lord, what happened was that before the gentleman was transferred, the gentleman who was in charge, the award was in the department. I can't say, Lord, he didn't have
you
knowledge.
become the law officer, the first thing you will do is check the whatever is pending.
He should have. This is what he has not done. This is Lord, the short point. Your lordship is absolutely right. The order was
officer, that will be the first thing he does.
After all, Lord, he is sitting in an office where it was.
Suppose he did not know the limitation period or those things. So whatever you have written in the subsequent paragraphs, Mr. Kaur,
yes,
that huge amount and all, he was very perturbed and sent for action. He should have done it on the first day of his office, or the second day, or the first week.
He was, Lord, he was inundated with the writ petitions. He was dealing with those matters, the current matters. He didn't. This perhaps lost sight of him, and this is the result of what has happened.
And Mr. Himanshu Shekhar Mondal was there till 17th of August.
17th of August.
For 1 month, he was still there.
He was still there. After the communication, sometimes
after the communication also 1 month he was still there. What was he doing?
He didn't.
He was acquainted.
He was acquainted, but Lord,
but then you will be treated to be a favored litigant then.
As I said, Lord, in a government office, Lord, it is very difficult to explain, Lord, on everyday basis. But your lordship is right that there was inaction on his part to start.
Have you taken any steps against either of them?
That I don't know.
No, not
I don't think so. I don't
go by this.
I don't think so. I don't think so. I don't think so. Accountability is the least of all things, Lord, that happens here. Everybody comes and goes. Accountability is the least of all. Now, Lord,
so delay is 1.5 years ago.
About roughly.
So it ended in 13th of August, on 13th of August approximately of 23.
11th of February 2025 was
it was filed. Yeah.
Was filed. And Lord,
August to August, 1 year, and thereafter about 6 months.
6 months. And
1.5 years.
Yes, it should have been filed within a period of 30 days. Except Lord,
so in their opposition, what have they stated?
547 days. I'm sorry, Lord, I mentioned the wrong date. It is about 547 days.
Yes, that is about roughly
and
roughly 1.5 years. What is their stand in the opposition?
Yes,
have to give you that also.
Lord,
this was a commercial matter.
Yes, arbitration. Lord, it's
commercial arbitration.
Commercial. It's assigned to your lordship. The matter is.
No, that's true. Yes.
Sir,
this was. I don't think it was filed as a commercial.
This was a non-commercial.
Non-commercial. It was filed as a non-commercial.
In opposition, they have taken a point regarding commercial.
Yes, they have.
That's why.
But Lord, if they say that it's a commercial matter, then Lord, they move the wrong forum. I mean, it allowed the matter to be adjudicated before a wrong forum.
I did not.
No, I am the person who
So please
challenged.
refer to section 34.
I'm the because if it is a nullity, the
But it
whole
did not take that point there.
no, that point was not taken. That point was not taken. Lord, they
Infrastructure. Yes.
right, except for delay, huh? They except for delay and no proper explanation. I don't think that there is basically a denial on affidavit is on denial.
So if first you have to get over this section 5.
Yes.
So let us hear Mr. Shenman.
Yes. Only thing, Lord, one judgment, if your lordship
Yes.
kindly consider. This is Lord 2025 SCC online Supreme Court page 600.
Inder Singh.
SCC online page.
Page SC page 600.
Inder Singh.
এখন সব এয়ার ড্রপে জাজমেন্ট যায়। Lord, kindly see paragraph 2. There was a delay of 5.5 years. Oh, sorry. It was about 14.
And that is section 5. The superscript is 1 of Limitation Act. Paragraph 2.
There was a long delay, Lord, in this matter. Kindly see paragraph 5. And paragraph 6, Lord, the High Court had condoned the delay in this case. There was a delay of 1500 and odd days. That your lordships will find in para 10. 1537 days.
Yes.
Paragraph 10, your lordships will find there was a delay of.
Yes.
Then, Lord, the judgment, Lord, operative part starts from paragraph 13.
Yes.
In the present case, the contention of the appellant on the first blush appears to be attractive inasmuch as state cannot be given any undue indulgence. As compared to an ordinary litigant, especially matters of limitation, there is no doubt that all parties, whether or not state under Article 12 of the Constitution, are required to act with due diligence and promptitude. There can be no quarrel on the settled principles of law that delay cannot be condoned without sufficient cause, but a major aspect which has to be kept in mind is that if in a particular case the merits have to be examined, it should not be scuttled merely on the basis of the limitation. In the present case, the file, this is Lord, a turn on the earlier view
Yes,
in 2004.
This is the only saving grace for section 5 applicants in recent times.
Because it tries to go back to the old age where the situation was that the merit
things were better. Yes.
In the present case, the filing of the review petition before the first appellate court was with a delay of 2 years and 4 months, and the second appeal before the High Court was delayed by about a year from the date of the dismissal of the review petition. Pausing for a moment, it is necessary to indicate that in the present case, the dispute over title of land is not between private parties, but rather between private party and the state. Moreover, when the land in question was taken possession by the state and allotted for public purpose to the Youth Welfare Department and the Collectorate, and has continued in the possession of the state, the claim of the state that its government land cannot be summarily discarded, we find upon a perusal of the record. This is Lord looking into the merits of the matter. And then it says, kindly, my lord, come down about 3-4 lines. It says, therefore, the delay of 1537 days reckoned from such and such. That is when the first appellate court decreed the suit includes 2 years and 4 months delay in filing review petition. dismissed on the ground of delay by First Appellate Court and about a year thereafter filing second appeal before the High Court. The peculiar facts and circumstances of the case, which at the cost of repetition relate to land claimed by the state as government land and in its possession, persuade us to not to interfere. Persuade us to not interfere with the impugned order. Relevantly, initially the suit was dismissed by the trial court. Then, my lord, the other judgments are considered where, my lord, long delay was taken into consideration.
No, but these are all previous judgments.
Previous judgments, and
but this is of a two-judge bench strength. The previous judgments also of two judges.
Yes, similar strength. 2024, it's the same.
Those were not dealt with here. Not
no. 24 is not not dealt with.
If it is not dealt with, Mr. Kaur, how far this is binding? Which will be more appropriate? Because in the sense that merits have been considered here.
No, your lord. If your lordship is looking at paragraph 17 once, please
Yes,
come back
17,
to paragraph 17. The judgments that are considered. First
That is 1974. Ramchandra.
87-2. Then, Lord,
this Ramchandra Shankar Deodhar is 1974. One SCC. Para 6, the previous paragraph it stated.
Paragraph starts with no doubt.
No doubt, huh?
No doubt, Ramchandra Shankar Deodhar.
Yes.
Ramchandra Shankar, the reference is given in the previous paragraph, 16.
16.
That is 1974.
Correct. And then, Lord, he considers, Lord, this
2019 concept.
no,
AB Govardhan is 2024.
24. That is considered. 2024 10 SCC 613 is considered.
তারপর গোবর্ধনটাকে কপি করে এই যে এখানে বলছি এইটাই
It is, Lord, the quotation that those paragraphs are quoted from Govardhan's judgment 2024.
Yes, yes. All right. So we'll continue with this. You also get into that bracket. Oh, Hardin part. List the matter for further hearing on July 29, 2026.
পার্ট হেডের উপরে চলে আসবে
Objection to
Today.
No,
Yeah.
earlier
That was previous.
There is an objection filed to the section 5 application. I find it from the records, but a hard copy I cannot.
We have.
Then
We
we have
also
not been
don't have that copy. If you have filed, yes, give us a
Could
copy.
be whatever in the meantime exchange and all, and we'll take a copy if necessary.
এই objection
Check up whether filed in the department and it's misplaced there from there. It's
No,
not before us.
It's not supplied to us.
Not supplied to
In
them
all
also. So please check up whether it was actually filed. You may have prepared, but whether filed. This শুধু যেটা supplement affidavit. Thank you.
With your lordship's please, may I mention, Blitz?
Yes.
Permission.
From that side, yes.
Well, may I have your lordship's kind leave, my lord, to mention, my lord, two connected appeals, my lord, for inclusion.
Those are already appearing.
My lord, it is not appearing. We have filed it as per the presentation form. It was to appear, my lord. Somehow it is not appearing in the
Under
list.
what heading?
My lord, for admission, your lordship, 4111.
What is the number?
My lord, number is FMA 813
Hello.
and the other one is 872. So grateful, my lord, so great.
Lordship, it's a humble prayer for the enlistment of the matter FAT 286
What,
of
application or
2025.
appeal?
Appellate side. It's IA number can 1 2025.
Yes.
Lordship, one restoration application.
Yes.
May I permit?
Request he kept in next week.
What about one?
Time next.
Not application, appeal. Yes.
May I permit you to mention a matter, my lord, for inclusion in the list?
What matter?
FMA 731
Under what heading?
can application.
What is the CAN number?
Can 1?
Yes.
The lordship, this is for inclusion in the list. It's an appeal for admission under order 40.
Yes.
Lordship, the matter that they had mentioned for inclusion, Your Lordship, my only prayer is, Lordship, if it can be kept next week, Your Lordship, because senior has to be briefed in.
Let it appear in the list whenever the file comes. We'll direct it to appear whenever the file comes. If you have any issue, you can mention. Yes.
All right.
For the inclusion in the list, my lord.
What?
Matter is the my lord appeal, my lord. In this matter, my lord.
Appeal hearing?
Yes, my
Sir, we are not taking appeal hearing matters.
May I be permitted to mention one matter, Your Lordship? This is an
Heading.
application.
Application, yes.
Past
Lordship,
appeal.
I'm mentioning for inclusion under that in application.
Yes.
And another for under order 41. Your Lordship.
Your quota is over today. Come back on.
With regard to item number 81.
81.
81. It is my lord, same order has already been passed by your lordship. Issue has been decided. I will take only 5 minutes time. Your lordship, I may hand over the judgment.
Keep the copy with you.
Any day, any day.
কাল কিছু স্পেশালি ফিক্সড আছে একটা আছে this will be the second specially fixed matter tomorrow we give a notice to the other side if you can next call on the list.
Lordship, may I be permitted to mention of order 41 rule 11
Come
matter?
on Monday yes তুমি mention দেখে নি তারপর ফিক্স হলে চলবে
This
why to be mentioned?
The application has been filed and my lord, the main matters are also appearing. My lord, what we are requesting is, my lord, if it can be, my lord, taken up, my lord, any day, my lord, convenient to your lordships, my lord. And my lord, all of them are appearing, 1, 2, 3.
The one judgment.
So why was it mentioned? I mean,
Lord,
why
mentioned
appearance
because
to
of that application, which we had taken out, because, my lord, the construction is complete, but there is a restriction, my lord, on us to.
application is not in the list.
Yes, application is also appearing. My lord, the application.
So what do you want now? The application to be updated?
Not the application. If the matter itself can
If
be.
this is the appearance, then it will be very difficult.
My lord, only request, my lord, innocuous prayer. My lord, first.
No prayer of yours is innocuous.
This one could. Well, this one could be, my lord. 1st August, my lord, if your lordship kindly takes it.
Yes, absolutely.
Yes,
this is really innocuous.
my lord, in this case, my lord, kindly fix this on 1st August.
One judgment covered all this. 1, 2, 3 covered by one judgment.
This is 1st August. We don't.
1st August, my lord.
1st August. Mitra is very happy. He'll have to come in any event.
I was wondering, my lord, what I was sitting on that day. I was sitting on that date.
Yes, we will be sitting. We have paid for that sitting.
My lord, 1st August.
In respect of can number 1, in WPLRT
In this matter?
140, in this matter, there are 3 WPLRTs, 126,
Those are not appearing in the
127 and
list.
140.
Not appearing.
They are appearing, they have not moved the can 1. We would like to use the opposition towards their can 1. In 140.
Everything is done.
No. 126. In connection. I'm sorry, in connection with WPLRT 126. 126. So it is not showing can 1 in relates to.
Okay, it is showing. Can 1 is there.
Yes.
So you want to use an affidavit in operation?
Yes.
So we'll direct affidavits to exchange in the meantime then?
Yes, sir.
Do it within 3-4 days so that
Yes,
they
sir.
can use a reply.
All right.
Or 2-3 days then.
Central government undertaking, I will have to draft the instruction.
You draft tonight. No. Then no opposition. We'll take it up.
No, my lord will.
Purpose for hearing.
That will be a ground in the affidavit if you use. Affidavits in connection with Can 1 of 2026 filed in WPLRT 126 of 2025 be exchanged in the meantime.
It will come on 1st August. Not okay.
The matter be listed
Under the
hearing. The matter be listed on August 1, 2026 for hearing.
Grateful.
For hearing.
Grateful.
No, first today we are on 22nd. So much time. No, within this week, by this weekend you do it, Mr. Ganesh. This week you're getting a weekend.
I am not. 1 week I am not there this.
No,
1 week.
Be wherever you are, you draft there. Yes.
But the original affidavits in the other
No, on the next. Yes, where is Mr. Chaudhary? Yes. You complete before Ms. Mukhopadhyay comes in. Yes. Yes, sorry.
No, it was a very pleasurable conference with a subdued Ms. Mukhopadhyay.
Why pleasurable conference? Why?
With a subdued Ms. Mukhopadhyay. But she's found some judgments.
Yes.
I also tried to find some, Milord.
Absolutely.
Milord, it's looking back at EL properties.
Mr. Banerjee is in this.
No, he's in the next matter.
He's in the next.
Don't assure him. He has to be on tenter. Yes.
Milord, first, Milord, is EL properties and admissions from me.
What EL? Oh, EL properties.
EL properties with other judgment. Milord, yesterday, what I said was I went and checked the plaint. It's possibly not right because of paragraph 7. I must show this because this
the
is
EL properties. We have a copy.
No, the plaint in EL properties.
Oh, acha.
Makes it not good for me, but that was the pleading.
Yes.
So, Milord, what I said, Milord, yesterday, I somehow, Milord, recollect me saying that the lease had started
1907.
under the Transfer of Property Act. How can it change midway? I remember saying that. But though we never really argued, main issue was something else. However, Milord, apropos my lord's findings, I thought I should read the plaint and tell your lordship. So that's Milord.
Even apart from the findings, you can, irrespective of that, you can satisfy us. If you are satisfied that that was the wrong view, then we'll refer it to a larger.
Yes, Milord. I think it was for me, Milord. I don't have too many briefs, Milord, in tenancy matters. So we keep learning every time we get a chance.
What are we doing here? Every other determination is a new determination, and you teach us the law, the bar.
Yeah,
bar teaches us the law. So what?
Milord, something I always say, Milord, that now I think maximum law I learn is from my juniors because they do the full research and give.
Yes, absolutely.
So, but Milord,
but we hope they did not do much research in this because
yes, we've done research, and let me start with the most important.
How many in total?
Yes, Milord.
Total how
I'll
many?
just cite two main judgments, both by your lordship.
Subsidiary judgments, how many?
Yes, Milord.
Subsidiary.
And similar short, one sentence, Milord.
How many?
2, 3. No, I am not the many judgment type.
Charu diesels is there.
Charu diesels is there.
Is there.
But
so
Milord,
let us forget that for the timing. Let us look at the, yes.
Number 1, Milord.
No, in your, I mean, you're also arguing that in Charu diesels there was an admission in the plaint.
Now, Milord, yesterday I was trying to tell your lordship that is not the issue because I thought I remembered.
But we have to go by whatever is there in
the judgment.
Yes.
Is there in the judgment. Well, I'll deal with it last. That's the least of my worries.
Right.
First concept, Milord, is when the Transfer of Property Act 1882, Milord, was enacted, all leases after that day were, my lord, covered by that act. Not Bengal Tenancy Act, I'm not going into at all. Now comes, my lord, 1956 West Bengal Premises Tenancy Act. Your lordships have read section 3.
There's an ordinance probably in 48.
Yes.
Whatever 56 Act, let us start.
56 Act. Net effect is rights already crystallized under Transfer of Property Act till 48 or 56, my lord, stands, my lord, altered. Legislature by legislation is entitled to alter rights under an existing legislation or under an existing contract.
Sure, definitely.
So on that premise, my lord, because the vires, my lord, of these rent acts have all been challenged in different states.
Yes.
Now, this is number one. So, crystallized rights under a lease deed has two, my lord, aspects. One, under the lease deed, and two, my lord, under the Transfer of Property Act. Both are capable of being altered and have been altered by the Rent Act. Otherwise, there's no point in bringing the Rent Act. Objective of the legislation is to give relief to tenants. This was the position. Now, matter, my lord, move forward, 1997. So the nature, my lord, of protection changed. Naturally, my lord, the rights which were earlier affected also stood changed. So somewhere, my lord, somebody had benefit under the 56 Act. He lost benefit under the 97 Act. For example, most of our commercial 2G, and then, my lord, it happened just when we came, that 10,000 rupee.
Yes.
So all that happened. Somebody got extra rights. So this is not what has happened. Now when 2002 Act comes, again there is a shift. And 2002 Act is, my lord, very clear. And I have now rights.
And 2002 amendment of the 97 Act.
97. And after the 2000, I'll just read the 2002 Act.
The amending Act.
No, the
97 Act with the
97 Act as amended in 2002.
Yes. Section 3.
Section 3.
Right.
Plot 3C. Any tenancy, I'll read from the top. Nothing contained in this act shall apply to C. Any tenancy where the lease with the due consent of the tenant has been registered under the Registration Act after the commencement of this act, and the fact of such consent has been recorded. So, my lord, post-act leases, Premises Tenancy Act will not apply. But pre-act leases, Premises Tenancy Act will apply. And if it does apply, rent here is below 10,000 rupees. So, my lord, Premises Tenancy Act will apply. Now, this is something which your lordship has considered. Lord, I want to rely on 2019 SCC Online Cal 9423. Oh, I'm sorry, I just handed up. Lord, Order 7, Rule 11 application on the ground of maintainability of a suit came up, my lord, for consideration, and Order 7, Rule 11 application was dismissed. 227, Article 227 application came up before this Honorable Court. Now, my lord, please come to paragraph 5. The trial court in all the 4 suits ultimately answered the 2 issues in favor of the plaintiff, holding that lease deeds were executed on such and such for a period of 99 years, and 1997 Act came into force on 10th July 2001. That is, the lease deeds were much earlier than the enforcement of the 1997 Act, and that there were no express word in the 97 Act with effect from 10th July 2001 that all rights accrued by any party from any prevailing law would be extinguished since the 1997 Act came into force on 10th July 2001. This is also important. Accordingly, it was held by the trial court that the four suits were squarely governed by the 1882 Act and not the 1997 Act. And in view of such factual aspect, the suits were perfectly maintainable. The moot question which falls for consideration is that which of the two acts apply. Now, my lord, kindly see paragraph 10. Paragraph 8, my lord, the 97 section 3, my lord, is quoted before or after. Now, my lord, before goes, it's only after. Now, see paragraph 10, my lord. Leases were terminated by notices dated 18 June 2007 on the ground of forfeiture due to default in payment of rent under section 111G of the 1882 Act. So, my lord, suit was based on that. My lord, I'll quickly take your lordship to, my lord, paragraph 22 on the next page. Paragraph 22 and 23. These are also arguments. As such, it is argued that in the present case, since the registered leases were of November 1992 for a period of 99 years from 1st November 1992 and without any sooner determination clause, let alone such clauses being exercised, the provisions of the 1882 Act were applicable, and neither the 1956 Act nor the 1997 Act afforded any protection to the lessee, being the defendant. In reply, learned counsel for the petitioner argues that sooner determination clauses, etc., clause F was relied upon. Then, Lord, next page. Lord, for this is important, Lord, paragraph 27, because this is how Prakashvati Chopra was, my lord, distinguished. Both Prakash and your lordship has also upheld that. Prakashvati Chopra and, my lord, Bengal Steel, two, my lord, judgments, both proceed on the basis that during the full tenure of if the lease runs full tenure, then, my lord, it remains unaffected by the Rent Act amendment. But those were cases, my lord, at that point of time, the Rent Act had that provision of sooner determination, etc., which is why that finding came in those cases. And that's what your lordship's finding also is. In fact, both were argued by Mr. Ananda Mitra. I got him outside. I told him, this is what I am arguing. Am I right? He smiled. I said, you argued Prakashvati. I'm trying to distinguish it this way. He again smiled.
That is also right.
So he didn't say anything. Just smiled. But I couldn't make out whether, no opinion expressed. For that, one has to be more persistent.
Yes.
Now, my lord, paragraph 33. Again, my lord, Prakashvati Chopra and, my lord, section 3C of the 1997 Act is considered. Even assuming that there was no sooner determination clause in the instant leases, question of terminability vis-a-vis actual termination becomes academic in this case, as Prakashvati Chopra did not even consider leases which had no sooner determination clauses. No mischief was needed to be remedied. Further, it is argued by petitioner that there was no discussion in Prakashvati Chopra as to what would be the effect on pre-1997 Act registered leases where there was no sooner determination clauses as in view of amended 3C of the 1997 Act. Hence, in the present case, literal interpretation of 3C is the only interpretation possible. That apart, it is argued that if the contention of the opposite party is to be accepted, section 3C of the 97 Act is to be effaced from statute book, since even in case of pre-1997 Act registered leases, without sooner determination clauses, Transfer Property Act would apply. Then, my lord, further arguments. The Act is, my lord, quoted. May I request your lordships to come to page 8, paragraph 41. Paragraph 41 is the finding. This is, my lord, the 97 Act unamended by the 2002 amendment. Now, paragraph 41, the finding, bare perusal of the amended section 3C of the Act shows that only those tenancies are exempted from the 97 Act where the lease was, with due consent of the tenant, registered under Registration Act and record such consent. However, plain and literal interpretation may lead to multiple results. Then your lordships have, my lord, dealt with, your lordship has not dealt with the multiple possible results. Prakashvati Chopra in detail. And, my lord, paragraph 52, from which I found inspiration to deal with, my lord, Prakashvati Chopra as I did. Paragraph 52, my lord, was very important. Division bench took into consideration post 97 Act registered lease deeds which complied with criteria stipulated in section 3C were exempt in any event. 43. That 43 and 44 are also of some relevance.
Yes, thought so. And you skipped, therefore we also skipped it.
Yes, I'm
We
sorry.
stuck to it a bit. 43 and
43 and
deal with what you
44
are
are most relevant. Yeah. First possible literal interpretation can be that
So this
leases
is after the
which-
multiple interpretation.
Yes, ma'am.
Multiple interpretation, then this. Yes.
Leases which were registered prior to the commencement of the 97 Act universally fall within purview of 97 Act since not exempted under section 3C. Secondly, it may also mean that clause C of section 3 restricts only the exemption to post 1997 registered deeds with the consent of the tenant recorded, but is silent on other categories of registered lease deeds. For example, there can be registered lease deeds executed after commencement of 97 Act, which though registered were not with due consent or do not record such consent, etc. Then lordship's finding.
But this is against you actually, 43, 44. Here we hold what we are thinking allowed on the last. Even if it is seen that a classification is made among equals in the present case between registered lease deeds on the touchstone of the date of execution, an exemption provided to one of the categories does not automatically imply inclusion of the other category within the ambit of the statute. So that is our logic also, the logic which you put to you on the last occasion. That exemption, this is an exemption clause. These clauses, these sort of deeds are exempted from this statute. That does not automatically mean that everything else is included in the statute.
Yes.
That was the logic here. So this 44 is against you.
No, I must read this. That's why I said it's important.
Hmm.
But not if your lordship looks at it that way, then the rest of it wouldn't really apply. The rest of the 97 Act would apply to no registered leases.
See, a lease deed cannot be in a vacuum. A juror relationship cannot be in a vacuum, statutory vacuum. It has to be governed by some statute. So in para 40 of this other judgment, Chadu, we held that only. That is consistent with this. That unless we are reading that for you.
Yes, yes.
Let us come to
I
para
have
40.
it
The
with
exact language is, once a lease commences under the Transfer of Property Act, it cannot automatically change its character and partake the nature of a tenancy under the Rent Control Act merely because such rent control came into force, unless specifically provided therein. Now, if it is specifically provided therein that these are also included, then fine.
Yes. Now,
it's specifically provided these are exempted, but not the reverse.
And exemption would also, my lord, non-inclusion would also have some effect.
That is where we differ from you. I mean, in logic.
Yes.
The fallacy which we are trying to, according to us, it's a fallacy. It may not be a fallacy. In your logic, is Mr. Chaudhary that I exempt particular things from the provision of the statute. On the date when it comes into force, we exempt certain things are exempted from the statute.
Yes.
That's an exemption clause. does not automatically imply that everything else under the
is
sun is
included.
included. Inclusion, 40 says inclusion has to be specific, in effect.
But
By
there,
statute,
Milord,
legislature, if legislation said the
but
reverse,
there, Milord, I would come to F3F. I come in differently. I come into 3F.
yes,
Any premises let out for E and F.
yes.
So E and F says any premises let out for residential purpose, not being a premises within purview of clause C, which carries more than such and such rent. So any premises.
So 3E and F.
Yes. E and F.
3C, E and F.
So C, my lord, takes out certain. Your lordship is right. It doesn't include the rest.
But E
I
and
accept. Doesn't include the rest. But E and F puts it to any premises. And E and F also says, not E says, not being a premises within the purview of clause C. So C is taken out from E and all other premises is applied.
Why shouldn't the same logic apply to E and F also? The one which we applied to C. This is an exemption clause. This says if it's above, out of this act.
Below
does not say whatever is below is within this act.
But that is the section. It says, my lord, I've got two arguments. Number one, the section only says that nothing contained in this act shall apply to and takes out the rest. So a class go out. And this definition, my lord, so class goes out. Now, my lord, see section 13(6) now.
6, yes.
Not with the two non-obstante clauses, starting notwithstanding anything to the contrary contained in any other law for the time being in force or in any contract. So, my lord, there's an exclusion. There's a void. Now, the void is, my lord, to be read with 6. 6 says everything else, any contract, any statute overrides transfer property act, overrides every lease deed. So therefore, my lord, if my rent is below, I get this protection. What am I fighting for? I'm fighting for the protection. And that protection, my lord, is given by this.
All right.
Now, my lord, paragraph 44 is my lord's finding. Now, my lord, please see paragraph 52 of the judgment. I'm not, my lord, dealing with the rest, my lord, because that's, my lord, dealing with Prakashvati Kaur. So I'm not going into it. But ultimately, paragraph 69, your lordship has held that Transfer Property Act does not apply. Otherwise, it will be not what your lordship is saying is the 3 classes. One class under Transfer of Property Act. One class under Premises Tenancy Act.
First of all, you start with the point of creation of the juror relationship.
Yes.
That is the first point. That is the first relevant point. At the point of time when that juror relationship was entered into between both of you, what was the prevailing law, which was then applicable, which is the transfer property. Subsequently, legislature can carve out exceptions, can include even there can be overlaps between the two, and the legislature can say that the overlap portion comes into the new act. Inclusion has to be specific, that is what we say. If it's
Inclusion must
specifically
be
included,
specific.
yes, then fine. If it's excluded, but it's a very arguable topic. I mean,
Milord,
you have to think
may,
on that.
May I request, Milord, normally I never request for adjournments.
No,
I'll
no
come back
further.
on Tuesday.
No
Let
further.
me do some
No further.
research.
This will never end.
Very interesting.
It goes to a point when it goes beyond the interest of the client.
No.
No, they cannot wait indefinitely, and
Yeah,
we also cannot wait.
If I get some time on
No, Mr.
Saturday, Sunday,
We'll do it in some conference or somewhere, academic something.
but then this judgment will be there.
No, we'll have to do the research work we have to do after we reserve judgment.
No, but why can't we help you?
No.
Very well.
Every time something will come up, you will then.
No, not. But this is
No,
very
we are
interesting.
not saying that you are taking. We understand.
I
the
never
academic
take
thing.
time, Milord.
No, you are not taking time as an excuse, Mr. Chaudhary. You are never saying that.
No.
But every time we are meaning to say we did not complete the sentence. I did not complete the sentence. Every time something interesting will come up, then we'll have to adjourn it for that. Because we are not sure that something more interesting will not come up in the next August.
No, and also
It may
Milord,
come up. It goes to the spiral is never ending. We are taking.
and also I have seen this, Milord. If it gets really interesting, then there is no direct answer.
Actually, we used to debate among our friends in law college. I mean, we tried to prove that day is night, actually, literally. And it can be proved. It can be proved. Day is night. There are certain logical sequence. You can prove that day is night. But there's no end to it. So let us.
Very well. Your Lordship has, Milord, got my argument. I'll just quickly show there's another judgment of a learned single judge which we found may be useful. কাগজটা দাও না।
এটাতে দিয়েছি ওটা গন্ডগোল হয়ে গেছে অন্য জাজমেন্ট নিয়ে এসেছে ওটা অনেকগুলো ছিল
Milord, we've made a mistake with the printing, Milord. If your Lordship sees this,
What is the
I'll
scientific
just give
reference?
then I'll give my learned friend also.
It's an unreported judgment.
This is yes, it's unreported. And if your Lordship just looks at the last page,
Last page.
Yes, page PDF
Yes,
page
it's
6.
the margin.
T Thompson, আমি এক্ষুনি দিয়ে দিচ্ছি। But I
can read out for Mr. Mukherjee.
Yes.
Otherwise, he won't have any.
No, I've
clue.
given him a
WhatsApp.
I've given it to him on WhatsApp and not some stray.
You give out printouts during the.
I'll just within
No,
half
to
an
us.
hour I'll give
To
printouts.
us.
Yes, Milord. Also to my learned friends. Now, Milord, may I rely upon that even though it is maybe I don't think it will be necessary, having regard to your Lordship's observations, I came prepared to cite even rights under a decree can be taken away by further rent acts. For example, to show that it's, I think, settled. But here, what had happened was that there were several eviction decrees.
Can be taken away, there is no doubt on.
So here, I won't go into the rest. It's now on that one question that whether what is excluded under section
That
3,
judgment is there that the rights accrued 2G judgment of the Supreme Court. That says that rights accrued under the 56 Act cannot be taken away by 2G. You have to deal with that also. Mr. Mukherjee must be citing that. He will be ready with that. So there, because Justice Banerjee and my bench held that no, it's a cloak of protection given by the 1997 Act. It's not a right, not an accrued right. It's a cloak of additional protection. Normal course, you are my tenant, lease expires, you go. That's an additional cloak of protection. No accrued right is there. But the Honorable Supreme Court held that no, disbelieved, turned down that view and said that no,
Accrued right.
it's an accrued right. Even, yes, airship, tenancy by airship is an accrued right, cannot be taken away by it.
Cannot be taken away.
That will go against you. He'll be citing that in reply, you can ask.
But that will not, may not go against me. Because right under Premises Tenancy Act is not an
No,
accrued
not
right.
Premises Tenancy Act.
Protection under rent, that's my distinction.
But
my lord.
right is both ways.
No, protection under Rent Act is an accrued right.
Landlord lesser had a right under the previous act to have an eviction.
Yes, which was taken away.
No, we agree with you, despite that judgment, in principle that yes, a subsequent statute can definitely take away, special statute on a field can definitely take away general
Existing
rights, existing rights also conferred by a general statute. Transfer Property Act is a general statute.
Yes.
Deals with transfers, not with rent control.
And that's been
protection.
held so also.
Yeah, held so in different judgments.
Different
That we agree fully. The bone of contention is only whether this exemption can be deemed to be such a
Inferred.
clause. It can be inferred.
Whether it
Yes.
can be inferred.
Yes.
Let me not.
The reverse logic can be inferred from.
Yes. So, Milord, just one more time for 2 minutes, Milord. If your lordship takes the act, I'll stop. Because this
Why stop only? Yes, very well. 3C or
3C.
something. Yes.
Kindly take the act, Milord. Section 3 first.
Section 3, yes. 97.
Yes, Milord.
Yes.
So, Milord, 2G tenant is defined. This is the premises is defined, tenant is defined.
Yes.
Now, Milord, landlord is defined.
Hmm.
Now we come to section 3. Which is exemption from, so once the act defines landlord tenant premises, the act proceeds to say that this act will not apply to XYZ persons. But if your lordship also sees, I think it will be there in section, Milord, in the section 1, subsection 3. Territorial limits, which kept getting, Milord, changed.
Yes.
Territorial limits and pecuniary limits in section 3 ENF. By saying that what is above 6,000 is exempt from this act, you're also saying that what is below 6,000 is part of the act. So if what is below, Milord, 6,000 and 10,000 is part of this act, then, Milord, 3C also would have a similar interpretation. I'm just arguing, Milord.
No, absolutely. It's a very valid argument. Very valid argument. Yes.
So if second, act, Milord, scheme of the act is section 1, subsection 3, extent territorial.
Yes.
Section 3, ENF, fiscal. And, Milord, exemptions are also mentioned. So, Milord, anything which is not exempted and is within, Milord, the territorial limits and the pecuniary limits would come within this ambit, and the protection is under section 6. That's the heart of the act.
Yes.
The heart of the act has two, Milord, non-obstante clauses. A, to take out Transfer of Property Act or any other law, and B, to take out any contract. You can't contract out of a statute, Milord. And this comes in because the legislature is conscious of the fact that there are existing registered leases. Now, if one argues the other way, Milord, let's take, Milord, an instance where a property to which the exemption does not apply is not deemed to be included. I have a tenancy of 500 rupees for which, my lord, there is no registered lease deed, which is within 1-3. Act will apply. My lord, that application is because of section 3.
So you mean to say that there is no provision in the 97 Act which includes specifically these things?
So there are two.
So we have to read the inclusion by
There are two parameters.
hint of 3.
Yes.
1 and 3.
Yes. 1 and 3, two
One is
parameters.
Territorial and other things. So we have to read 3 to know what is there in the statute also.
And that's what your lordships have always done.
Otherwise there would be nothing in the
Nothing.
statute.
Nothing. And in this universe of, my lord, leases and tenancies which are outside the 3 exemption, there is no, my lord, class distinction between registered leases under Transfer of Property Act, etc. And that this universe is one is made clear by the non-obstante clause at the beginning of section 6.
All right.
So this is my argument. I'm grateful.
Yes.
The lease had expired, my lord, in the year 2005, which was, my lord, of the year 1907. Initially of 1905, then, my lord, 1907, and, my lord, it had expired in 2005. I filed the suit in 2006 after commencement of, my lord, the 1997 Act. The point that my learned friend, my lord, urges before your lordship about, my lord, that it is covered under, my lord, the Premises Tenancy Act was never taken in the written statements. This is for the first time coming before your lordship, but I am not shy of arguing before your lordship about the point taken. But it was never taken in the written statement. With a multitude of defendants, not only defendant number 27 had filed the written statement and 6 had filed the written statement, and effectively, my lord, it was opposed by defendant number 27 there. Now, my lord, before I take your lordship, my lord, to the ambit of the judgments that your lordship had passed, but may I just not, in my own way, my lord, try to interpret what that is there in, my lord, section 3, because that is what my learned friend is trying to argue before your lordship, that what that is not there in the statute is urging your lordship, my lord, to interpret that by necessary implication. This is the sum and substance as I understand. So, my lord, the section 3 of the Act, my lord, is, my lord, carving out, my lord, what that does not come within the purview of, my lord, 1997 Act. So, my lord, it says that nothing contained in this Act shall apply to. So, my lord, they are carving out, my lord, what should not be coming within the purview. Then when we come to, my lord, see any tenancy where the lease with the due consent of the tenant has been registered under the Registration Act after commencement of this Act. My lord, these are very important. Why I say this? Because my way of looking at this particular section is, my lord, there may be a tenancy existing. The tenancy after commencement of the Act with the consent of, my lord, the tenant has, my lord, changed the character to a lease. May I just, my lord, in a more simplistic way, my lord, try to explain this. After commencement of this Act means, my lord, the Act of 1997. Prior to that, my lord, it assumes that there was a tenancy. The tenancy after commencement of the Act with the consent of, my lord, the tenant. That's the purpose. And the fact of such consent has been recorded in the instrument so registered. Otherwise, my lord, this particular words in the statute would have been redundant. In those classes, my lord, it has been stated to be excluded within the purview of the statute.
So the registration is with the consent of the tenant.
Yes. And, my lord, the registration in respect of a lease with the consent of the tenant after coming into force of the statute. Of this particular Act, I mean.
Yes, yes.
So when there was a tenancy, after commencement of the act, with the consent of the tenant, culminates to a written lease, and in the lease it is written that with the consent, that comes outside the purview. So, in this particular case, it doesn't attract that section at all. Why I say, the lease was the prior lease, much prior. It is not after commencement of this act.
So then it's not exempted according to him. Mr. Chaudhary says it's not exempted then.
No,
Then
but
comes within this.
it is not covered under what I say is the Transfer of Property Act. Because the start of the tenancy was by way of a lease.
Yes.
The lease at that point of time was governed under the Transfer of Property Act.
Yes.
So it had run its entire course by a flux, and repeatedly your lordship as well as Prakashvati's judgment says that when it has been allowed to run the full course, the provisions of Transfer of Property Act will apply. The judgment which my learned friend has shown before your lordship, Vijay Kumar, Manish Kumar, the judgment, your lordship there had held, in the paragraphs, maybe from 64 onwards, your lordships tried to say that since there was a sooner determination clause, and therefore 111G, the forfeiture clause, was attracted. Therefore, your lordship was of the opinion that Transfer of Property Act will not apply, but the Premises Tenancy Act will apply. So, if your lordship kindly comes to my lord's that judgment which my learned friend handed over today, at paragraphs, I'll just paragraph 56 onwards. The line of distinction between 1956 Act and the 1997 Act was drawn in Prakashvati Chopra, inasmuch as 1956 Act laid stress on mere terminability of the lease, that is the mere existence of a sooner determination clause, which was sufficient to extend the protection of the 1956 Act. However, as per the division bench, the 1997 Act restricted such protection only to cases where the lease was actually determined sooner than its normal date of expiry. The moot question on which the present case hinges is whether the expression sooner determination can be confined merely to the existence of an actual clause contemplating sooner determination of the lease deed, an exercise of such clause at the option of either of the parties, or even a sooner determination by virtue of a forfeiture, as contemplated under Section 111G of the 1982 Act. An attempt has been made on behalf of the opposite party to restrict the meaning of sooner determination clause to the third clause of Section 110 of the 1982 Act. Read with Section 111H of the said Act, a bare reading of Section 110 and its heading shows that the same pertains to exclusion of the day on which the term of the lease commences. The entire ambit of the said section revolves around the duration of a lease. In such context, the last clause, which has caption option to determine lease, stipulates that where the time so limited, meaning as per the first clause, the time limited by a lease of an immovable property is expressed to be terminable before its expiration. And the lease omits to mention at whose option it is so terminable, the lessee and not the lessor shall have such option. The clause H of Section 111, on the other hand, contemplates the determination of a lease of an immovable property on the expiration of a notice to determine the lease, or to quit, or of intention to quit the property lease duly given by one party to the other. Although both the said clauses would apply to a case where lease deed contains a specific provision as to determination of a lease earlier than its normal life, it cannot be said that the expression sooner determination as contemplated in Prakashvati Chopra has to be restricted to such provision. The provision of Section 110 of 1982 Act has to be seen in its perspective, being specification of the duration of a lease. Section 111H, on the other hand, does not envisage by itself any sooner determination clause, but provide a mode of determination of a lease in the event either of the parties give a notice to quit, taking into its ambit not merely the lessee invoking the sooner determination clause, but also a lessor giving a notice to quit, be it under Section 111G or even Section 106 of 1882 Act. The stress laid by the learned counsel for the opposite party on the scope of Section 108Q of 1882 Act, which provides that one of the liabilities of the lessee was that of on the determination of the lease, The lessee is bound to put the lessor into possession of the property does not have any relevance to the context at all and was only a prop used by the division bench while rendering the judgment in Prakashvati Chopra to interpret the intention of the legislature in extending the protection to a particular class of lessees stroke tenants. As far as the judgment of Bengal Steel Industries Supra is concerned, the same also pertained to a case of expiry of a lease by a flux of time. In fact, although Prakashvati Chopra has referred to therein, it was stated in paragraph number 46 of the said judgment that the plaintiff's assertion that the matter was covered by the dictum found in the first sentence of paragraph 29 of Prakashvati Chopra still begged the question as to whether the third defendant could be reckoned as a monthly tenant under 1956 Act by reason of the express term as to tenure in the indenture of lease. It was held that if she was indeed a monthly tenant protected by 1956 Act, then by reason of the nominal rent, the third defendant can also be a tenant protected under the 1997 Act. In such a situation, it was held there did not appear to be any exemption plainly visible under Section 3 of 1997 Act to take the third defendant beyond the ambit of the definition of tenant thereunder. As such, as such, the said judgment is not relevant at all in the present context. In this regard, the judgment reported in such and such are to be taken into consideration, and the judgment rendered previously has to be treated as a precedent only for what it was actually held in the factual context of the case, and not as a statute by discussing as to what would be the logical interpretation of what was held therein. Then, paragraph 64.
64 may be important.
That is not, I just read the prelude, otherwise, yes. Thus, it is absolutely clear in the light of the judgment pronounced in Prakashvati Chopra that the said judgment shed light on the grey area left open by the silence of the exemption clause in Section 3C of 1997 Act as to post-1997 Act lease deeds, not containing any provision as to due consent of the tenant in that regard, and in respect of pre-1997 Act lease deeds in general. The ratio clearly laid down in Prakashvati Chopra was that only in cases where the lease was permitted to run its full life, the same would be governed by 1882 Act. Otherwise, if an option was exercised for sooner determination of the lease than its normal tenure, the protection of 1997 Act would be attracted. So, Lord, this is where, Lord, basically, Lord, the ratio has been let down, which, Lord, fits the fact of my case here. The said conclusion was drawn in the light of Section 2G of 1997 Act, which brings within the definition of tenant persons whose tenancies have been terminated but are continuing in possession of the suit property. But in that context, your Lordship knows, Lord, the Supreme Court judgment, I'll, Lord, cite it for the purpose of, Lord, what it brings within its ambit, or, Lord, it takes it outside the scope of, Lord, the definition of 2G. That was, Lord, basically the principle. The right vested at that point of time cannot be divested by a subsequent legislation. But that is not what the principle of, Lord, the
judgment may be relevant here.
But that I have asked her to print out, Lord. But I'll just be giving a copy to Mr. Chaudhary.
Yes, yes.
For a Supreme Court at a judgment in the context of 2G and 2H. Right.
No, he knows that.
Yes. Then, Lord, paragraph 66 in the present case, although the registered deed was entered in the year 1992.
That is more on sooner determination. Sir.
Sooner determination.
With the sooner
So
determination
that
is restricted to
basically,
clause or
Lord,
yes.
your Lordship was on, Lord, 68. 68 and 69.
Yes. Since there was a sooner determination, actual.
Lordship.
Very well. Yes.
Although your Lordship has dealt with Prakashvati, Lord, the relevant, Lord, the paragraph, Lord, which deals with, Lord, the proposition, Lord, which Mr. Chaudhary is, Lord, forwarding before you. But I'll just, Lord, point out that. Paragraph 24 and 25.
Yes.
In 1956 Act, thus applied A, para 24.
Yes, yes. Oh, sorry.
A, to all leases for less than 15 years. B, to leases for 15 years or more, if for residential purpose and entered into after 1st December 1948, But before 24th August 1965, insofar as the provisions regarding rent and the sections 31 and 36 are concerned. C. To all leases executed after 24th August 1965, terminable before its expiration at the behest of the lessor or lessee. And D. To all leases executed after 1965 for a period of less than 20 years, whether terminable or not before the expiry of the period at the behest of the landlord or the tenant. 25. It would thus appear that great emphasis was given by the earlier act on the terminability of the lease. If a long lease for more than 20 years was terminable before expiration of its term, it would be covered under the act and all the provisions thereof would apply as indicated herein above, irrespective of whether such a lease was in fact terminated before the expiry of its term. We are of the considered opinion that this situation was thought to be remedied by the new act when it provided that a person continuing in possession after termination of his tenancy shall be within the definition of a tenant. Mere terminability of the lease is no longer the criteria. In order to bring a pre-act registered lease within the fold of the Tenancy Act of 1997, one has to show that the lease has in fact been terminated prematurely, only then it would come within the mischief of the act. But it would not come within the mischief of the act after the lease has been allowed to have run of its normal life. In other words, the lease will not come within the purview of the Act of 1997 if it expires by efflux of time. It is also worth noticing that under Section 3 of the Act, a registered lease executed after the Act came into operation is specifically excluded from the purview of the Act of 1997. But that is not the text. Therefore, the legislature has rationalized the old Act in a mere terminability is no longer material. It is actual termination before expiry of lease is what is material. And in the case of a new registered leases, parties have been given absolute freedom. This interpretation subserves the object sought to be achieved by a new legislation. It would at this stage be profitable to notice the object of the Act of 1997. Lord, I am Lord, not reading that for your Lordship. Lord, thereafter, Lord, the sections have been Lord quoted. Then Lord, paragraph 29. We are therefore and of the opinion that in those cases where the lease expired by efflux of time, but the lessee is continuing in possession, he would not come within the purview of the definition of a tenant under Section 2G of the Act of 1997. 29. The judgment in the case of Shamcharan does not really lend any assistance in resolving the controversy involved in the present case because the Act of 1997 has to be construed in its own background and not in the philological manner as suggested by Mr. Thora. The first point is thus answered in the negative. कॉपी में वो अच्छा अच्छा
Yes.
Lord, your Lordship's judgment, Lord, the other one which Lord, my learned friend was Lord placing the Lord, my Lord's judgment in Charu Diesel.
Yes.
Lord, there also your Lordship was Lord at paragraph 39. If your Lordship kindly comes to my Lord, the copies.
Yes.
The specific, Lord, the issue that your Lordship dealt with, Lord, whether the plaintiff was a lessee under the Transfer of Property Act 1882 or a tenant under the West Bengal Premises Tenancy Act. So that is the heading, Lord, that your Lordship was, Lord. I am not, Lord, concerned with the other ones. Then, as I have pointed out before your Lordship, Lord, paragraph, Lord, 40, that your Lordship says that on a once lease commences under the Transfer of Property Act, it cannot be automatically change its character and partake the nature of a tenancy. under the Rent Control Act merely because such rent control came into force unless specifically provided therein. So here what happens, my lord, in section 3C is, my lord, that there is a tenancy. The tenancy gets converted to a lease by the consent of, my lord, the tenant recorded in the lease deed after commencement of the act. Therefore, my lord, there are 4 elemental features in, my lord, that particular section. To any tenancy, shall not apply to any tenancy, which after commencement of the act with the consent of the tenant, not a lease is registered.
But Mr. Mukherjee, one problem that by that logic, that the exemption clause cannot be the logic given in Chadu by us. That merely because, I mean, it automatically does not change.
Lordship.
Now, therefore, by that logic, it may be argued that then nothing would come under this Act, 97 Act. In the sense, we are just saying, apart from the exemptions,
Lordship.
now, let us take F, as Mr. Chaudhary cited. Any premises let out for non-residential purpose which carries more than 10,000. The presumption is that if it's less than 10,000, it comes within this Act. If it's a premises let out for non-residential purpose and carries less than 10,000, then it comes within this Act.
But that depends upon, my lord, whether it starts with a tenancy agreement or, my lord, it starts with a lease. If it starts with a tenancy agreement, absolutely, my lord, there is a, my lord, a pecuniary bar. Now, my lord, once, my lord, somebody does not, my lord, comply the threshold of, my lord, the pecuniary bar, my lord, the relief lies under the Transfer of Property Act. Because of the exclusion, my lord, that is contained in section 3. Section 3 says that anything beyond, say, 10,000 rupees in a commercial property, the Act will not apply. So, my lord, the rent which are paid, my lord, in respect of those tenancy agreement, where, my lord, the rent is more than 10,000, goes outside the ambit of this particular statute, the protective rent statute. Then, my lord, the recourse is, my lord, falling under section 5 of the Specific Relief Act, read with, my lord, the Transfer of Property Act, as the case may be.
So, therefore, this Act would operate in the penumbra region, or rather the region in between this exemption and where Transfer Property Act actually applies. So, under 107 of Transfer Property Act, a lease of immovable property from year to year for any term exceeding for any term exceeding 1 year. This was exceeding 1 year, it's a registered. So, that can be made only by a registered instrument. That comes within the purview of this 107, and therefore it came under 90 Transfer Property Act. There are several judgments where it has been said that if it's by the other mode, without registered instrument, by oral agreement had delivery, it will be treated to be a monthly tenancy.
Lord, in 1956 Act, your lordship may remember, Lord, there were, Lord, the certain classification of leases which were brought within and which were outside.
Exactly.
So, Lord, that was in the realm of 1956 Act.
Yes.
Which has been, Lord, stated in paragraph 24 of Prokashwar.
Right. 1956
Thereafter,
was
Lord,
clearer in that
1997,
sense. Yes.
Lord, it has been, Lord, ironed out. The ironed out by even by an amendment in 2002. Because, Lord, if your lordship sees the amendment, that will also give, Lord, a certain, Lord, clarity on, Lord, what it was intended.
If that clarity is sought, then it would be more in favor of Mr. Chaudhary, because previously it was all registered deeds before after exempted. Now before goes, only after remains. So by necessary implication, shouldn't it be construed that the intention of the amendment was that post-act, post-97 registered come within with consent and pre-go out?
Lord, it is in my Lord, interpretation, Lord, kindly see, Lord, 3C says the Act will not apply to any tenancy. I'll stop there. Let us see, Lord, how it starts. Nothing contained in this Act shall apply to any tenancy. Then,
apply to.
Yes, nothing contained in this Act shall apply to.
Any tenancy where?
Now coming to, Lord, see any tenancy. Which tenancy? Where lease with the due consent of the tenant has been registered. Meaning thereby, the tenancy was there. The tenancy got converted, my lord, to a registered lease deed with the consent of the tenant. This doesn't talk about, my lord, a pre-existing lease.
Why do you say that it can be a new tenancy also? Any tenancy where lease with due consent of the tenant has been registered. Watch, two expressions are used.
Yes. First, it starts with a tenancy. Then, Lord, the tenancy gets, after commencement of the act, to Lord a lease with the consent of the tenant. So, the basically a tenancy, when converted with a leasehold right after with the consent after commencement, this act will not apply.
No, no, any tenancy.
Otherwise, it should have been any tenancy which has been registered with consent.
Yes, because Lord, kindly see the other Lord, the exclusions, Lord, in section 3R, Lord, all are Lord about that where the act will not apply. The protective, Lord, the arms of the act will not extend to.
So then where do we draw the line? Suppose, I mean, because under F.
1997, according to me, is very clear on the point, Lord. Because Lord, when it started with Lord 1882, Lord, it cannot in the midway first, as it fell from your Lordship in previous judgment,
That's
cannot be
the
Lord,
general-
coming within Lord the 3C provision. That they cannot Lord seek that I am protected tenant under the Premises Tenancy Act. One. But there could have been Lord, of a line of argument which Mr. Chaudhary was trying to forward before your Lordship. Lord, that
What would, to what, which leases
a
should
lease,
this apply? There is no inclusive
a
clause.
lease which was executed after coming into force of 1997 Act without the consent of their tenant.
Registered without the.
Registered. Lord, it also says, and the fact of such consent has been recorded in the instrument so registered. Therefore, Lord, this consent means that the tenant's consent to have the tenancy converted to lease written down, recorded in the registered
So
instrument.
this is a small area created. This will be beyond this act. What? Executed after, registered with consent after 97 Act. So what happens if it's a registered document without consent before the 97 Act? Then by necessary implication, shouldn't this act apply to that? Because that's not within the exemption then.
Lord, it is
Double
only
negative,
restricted
not within
to,
exemption.
it is only restricted to Lord those after commencement of Lord this act. Otherwise, Lord, after the commencement of this act and such fact of such consent has been recorded in the instrument so registered.
Then Mr. Mukherjee, the section 3 would merely say any tenancy entered into prior to commencement of this act. Why going to this trouble?
Because Lord,
that would be the exemption.
Why it says, Lord, in my understanding, Lord, it assumes that there is a tenancy. There is a tenancy. Now the tenancy is taken outside the ambit of the protective wing because of the fact that the tenant has consented to have it converted to a lease.
The language of C is a bit
But that is
unhappy.
exactly Lord, what the language may not be very happy, but the intention is very clear.
Very happy for the landlord.
It will not apply to any tenancy where the lease.
And we could understand any tenancy where the lease
to any tenancy. Where
use lease and tenancy in the same.
Where the lease with the due consent of the tenant has been registered. After commencement of this act. I'm not reading what is redundant. And fact of such consent has been recorded in the instrument so registered. So Lord, this is another condition. That the tenant consents that my tenancy is now a lease because lease might be for a definite period and tenancy might be terminable on a notice. So Lord, it is a...
It may be argued to the exact contrary to that, Mr. Mukherjee, to take yourself outside the purview of this act, there has to be a conscious relinquishment of the applicability of the act by the tenant. Because with the consent of the tenant...
Yes.
Because
due consent of the tenant.
So why this? Because by default the tenant is governed by this act.
Lordship.
To go outside the purview of this act, you have to have it registered with the consent of the tenant.
Yes.
Because what the relinquishment is on the part of the tenant of the protection by this act.
Yes.
So therefore, by default, the argument can be, by default, this act is applicable to all tenancies after this act comes into force. But to go out of the ambit of this act, to relinquish that protection, you have to take the consent of the tenant because it is he who is suffering. So that's why with consent of tenant registered with the intention to go out of the act. So by default, you are governed by this act. But to go out, you have to take the consent of the tenant who is suffering.
I'll try. Now, my lord, this is what fell from your lordship is right to the extent when, my lord, the tenancy is created by an agreement. Why I say this? The tenancies are generally created by agreement, my lord, optionally registered. So, my lord, there is a tenancy, my lord, which is existing. This 1997 Act comes into force. The 1997 Act says that if you as a tenant consent to enter into a registered lease, the registered lease is, my lord, gives a tenure to the tenancy. And the tenancy governed under the Premises Tenancy Act is, my lord, at the, my lord, the pleasure of the landlord, subject to, my lord, the statutory notices and compliance of Section 6.
But protection is more in the Rent Control Act.
No, my lord, it is not a.
There it can be by 15 days notice.
But, my lord, subject to, my lord, the forfeiture and other clauses. But that gives, my lord, a guarantee of a tenure to a tenant. In a lease,
That's
lord,
illusory. That's illusory. Because the regards are more for the tenant there. Because just by a 15 days notice, I can terminate.
But because, my lord, the tenant has opted, my lord, for a more secure or, my lord,
this is more secure. Protection of the Premises Tenancy Act, you can linger for years.
106 এর কথাটা আমি বলছি। But otherwise, my lord, kindly see, my lord, this taking outside the purview by the legislature was contemplated because, my lord, that was conferring, my lord, a better security, my lord, to the tenant. I understand, my lord, the purpose of, my lord, the Premises Tenancy Act.
It's obviously to give more protection, protective cloak of protection to that is used by the state.
But when, my lord, a particular person, my lord, opts to have a, my lord, a lease,
it relinquishes that cloak. Relinquishes
then,
that.
my lord, it relinquishes the cloak of protection.
That means by default it was available to him, which he relinquishes.
Right. But that may be because of the fact that he opts for a lease. A lease might be having a different, the nature under a different statute and the level of protection.
Yes.
So, my lord, it is all about, my lord, that under which act you give yourself to be controlled with. So, my lord, here, as I say, my lord, this section 3C, as I read it, my lord, in the context of my case, my lord, it does not come within, my lord, within the periphery of what Mr. Chaudhary is arguing as of today. If, my lord, there is a lease which was entered, registered lease, which has ended in 2005, and I file a suit in 2006, but there cannot be, my lord, an interpretation to say that, my lord, the provisions of, my lord, the Premises Tenancy Act will apply in those type of cases.
Suppose this act was not there, 56 Act was not there, then in normal circumstances, every monthly tenancy will be governed by the Transfer of Property Act. That would be the scenario.
But even now, in those areas where, my lord, the Premises Tenancy Act doesn't apply, it does apply. I mean, the 1882 Act.
Yes, but
these are also territorial.
By that argument, by that logic, then even tenancies, unregistered tenancies, which are below 10,000 rupees or 5,000 rupees at the case maybe, that also cannot be governed by this act because it becomes very fluid. Nothing apart from the exemptions, only exemptions are given, but inclusion is not given. No, there is no inclusion clause here. So shouldn't it be by default, whatever is not exempted should come in?
No, Lord, not by a necessary implication. That will not create a. Lord,
but then nothing will come under this act. The exemptions are given.
Lordship.
Suppose it's a monthly tenancy which was created under the Transfer of Property Act, coming within the second and third clauses of Section 107, not registered, etc. So there are judgments which say it will be deemed to be a monthly tenancy otherwise. So then if it's a monthly tenancy...
That is a monthly tenancy not under the Premises Tenancy Act.
No, that is under the
Transfer. That is also under the Transfer
but
of
now
Property
after this act, if it's under 10,000 and under 5,000 respectively, it comes under this act.
No, but this...
So, which was originally a Transfer of Property Act tenancy, after this act comes under this act.
Blood, in my respectful submission, blood, not that all, blood, the tenancies which have been created under the Transfer of Property Act, blood, giving a rent of, blood, what that is specified here falls within, blood, the Premises Tenancy Act. Why I say this?
Why do you draw the line? What is not coming?
Now, blood, the Premises Tenancy Act, as your lordship knows, blood, it applies to, blood, a particular territorial, blood, the limits where it has been, blood, notified. Therefore, blood, it is not universally applied, blood, in the state of West Bengal.
Where there is an overlap, let us think of those areas.
Well, now, blood, so far as, blood, the ambit of its, blood, the application.
It's a special statute.
This is a special statute.
Special statute.
Yes.
So it can override transfer.
And this is also not a state statute, and not the Transfer of Property Act is a central statute.
Central, but that would not apply because it has been held in several judgments that this Rent Control Act protection can be, can override normal Transfer Property Act. Because Transfer Property Act otherwise would be applicable to every rent control lease also. It is not applicable because this act has come in and given an additional cloak of protection. Question is to whom?
Now, Lord, let us assume, Lord, in the city of Calcutta.
Yes.
Lord, there is a lease. There are a lot of leased properties.
So if territorial is not applicable, then this question does not.
Talking about the city of Calcutta.
Yes.
A property, Lord, maybe anywhere, Lord, is governed under a Lord of lease for a particular year and registered.
Yes.
Now, Lord, whether those classes of Lord the lessee can be said to be a premises tenant or not. So, Lord, in those cases, according to your Lordship, Lord, if it crosses the threshold of 10,000 in a non-residential property, then Transfer of Property Act will apply.
Because it's exempted.
And Lord, in less than 10,000, the question is whether they will be premises tenant or they will be governed under the Transfer of Property Act.
Yes, because otherwise they would be governed by Transfer Property Act unless this act came.
There is no overlap of Lord both the statutes according to. Lord, your Lordship has to see under which provision, Lord, the jural relationship has started.
That is where Mr. Chaudhary's argument comes in. Whatever is not exempted in an area territorially covered by this act, let us proceed on the basis that this act territorially governs that area. We are speaking only of those areas. Now, it says that tenant has been defined, landlord has been defined. There is no classification there. We can't find anything there. Territorially applicable. Certain leases exempted. Then why shouldn't all the other leases within that area come in?
Lord, kindly see.
With my learned friends, just one struck me suddenly when your Lordship, when Mr. Mukherjee, when we were discussing, Lord, please see once. Any tenancy is a tenancy under this act. So all tenancy comes in 3C. All tenancy comes in, and then the exemption where lease has been registered under the Registration Act. So we start with everything in same way which I had submitted. Territory, pecuniary. So everybody comes in and then some go out. And what fell from your Lordship, my Lord, that this
Consent of tenant.
Yes, consent of tenant because you're giving up a right.
Now, Lord, coming back to Lord, the question that fell from your Lordship. Now, Lord, in those cases, Lord, your Lordship has to, Lord, for applicability of this act, Lord, two things are to be seen, Lord. Whether it is a premises or not, as per the definition under 2E.
Yes.
That is, Lord, one of the moot point, because, Lord, in cases of, Lord, leases at time, your Lordship will not find, Lord, that the premises is there, but for a bare land too. There might be a possibility in cases of a lease. Yet also there are, Lord, classes of lease where, Lord, the property is let out. The built-up property is let out. So, Lord, it has to be a premises within the meaning of, Lord, this section 2E. 1. Now, Lord, so far as, Lord, reading the definition of a tenant, your Lordship will not find much of, Lord, to take out, Lord, from its ambit what is governed under the Transfer of Property Act, or, Lord, what is.
There's no clue in the no clue in tenancy, no clue in landlord.
The only thing is that, Lord, the use of the word rent is not it is a generic word used here. It might be a lease rent or a tenancy lease. Now, Lord, only thing, Lord, that I could, Lord, assist your Lordship, Lord, to say that when your Lordship sees the exemption in 3, Lord, any premises owned by the central government and all, premises being a Waqf, tenancy created by the central government, because these are covered under, Lord, a different statute. Then, Lord, the premises rented to a foreign mission, tenancy created. Then, Lord, any premises let out for residential purpose, not being a premises within the purview of clause C, which carries more than. Therefore, in E, there is a reference of clause C.
Yes. Yes, yes.
Your Lordship has seen that. So, my Lord, when your Lordship, my Lord, reads E with reference to C,
That
it
that
creates
is where,
the
yes, that is also all the more it indicates that any premises let out for residential purpose not being a premises within the purview of C.
yes,
So if it is not within C,
Lordship,
anything else than from C,
Lordship, which carries more than 6,500 as monthly rent in the areas included within the limits of Calcutta Municipal Corporation or the Howrah Municipal
it
Corporation.
has to come out of C in the first place because otherwise C itself would operate and exclude
Exactly. Exactly.
it. Understood. Yes.
Exactly.
So if it is out of C, then all the rest,
then
including previous TP Act things also,
yes,
then 6,000 and above,
then not
excluded. But then by necessary implication, if below that,
yes,
as in your case,
Lordship,
then it would come under this act.
no, not why I
C,
say, first of all, I do not come within C.
you don't come within C.
I do not come within the
Therefore,
C
this
by
applies any premises let out not being a premises within the purview of C.
Lordship.
You are not within C.
No, my basic argument is, my Lord, that the any tenancy means, my Lord, there is a tenancy not under the Premises Tenancy Act. I mean to say a tenancy under the Premises Tenancy Act.
Yes.
If your Lordship says that the tenancy is also to be a tenancy construed under the Transfer of Property Act, that is not never contemplated in this statute.
Let us take it as what you are saying.
The tenancy under the Premises Tenancy
Yes.
Act 1956,
Yes,
not
yes.
under the Transfer of Property.
Yes. So any tenancy where lease with due consent of tenant is registered after this act goes out of this act.
That is. Otherwise, my Lord, there was no
But
necessity.
then any tenancy where it does not happen,
Lordship.
where there is no registration with consent.
But my Lord, this tenancy is talking about, my Lord, the tenancy which was pre-existing under the provisions of the Premises Tenancy Act. It doesn't talk within its ambit that a tenancy created under the Transfer of Property Act. Because if a tenancy is created under the Transfer of Property Act, my Lord, your Lordship knows, my Lord, the rights are there which is flowing for forfeiture and, my Lord, the regularization, holding over, my Lord, the
Several
multitude of
incidents.
sections are there.
Several-
Therefore, my Lord, a person who is having, my Lord, a lease under, my Lord, the Transfer of Property Act cannot be denuded of, my Lord, the rights which is flowing from that particular act.
That was our initial premise, but the language of the statute.
Now, my Lord, here, my Lord, only confusion is coming about, my Lord, whether, my Lord, with the word tenancy used here, if your Lordship, my Lord, includes, my Lord, the Premises Tenancy Act tenancy and
Well,
the
as-
Transfer of Property Act tenancy to be synonymous, then only, my Lord, it gets difficult.
Yes. Yes.
Therefore, my argument before your Lordship is, my Lord, the tenancy which is referred to here is a tenancy, my Lord, under the Premises Tenancy Act. So that is the real reason. I'm sorry.
Very good. বলুন। তখন আপনি বলুন যাতে ও
Under the 1997 Act,
My Lord,
it has not been mentioned that it is given a retrospective effect. It is not mentioned.
It goes in your favor.
Not about the favor. Lord,
No,
this is
I mean,
trying to assist your Lordship to come to a just
your propositions favor.
Lordship.
Mr. Chaudhary will have to answer this later when he comes in.
If it had been mentioned that it is being given retrospective effect, then Mr. Chaudhary's argument is applicable that all prior to 1997.
But in fact, when your Lordship sees, my Lord, the preamended
Therefore, substantive
provision,
rights cannot be taken away.
Lordship.
Substantive rights cannot be taken away unless it statute specifically says it's retrospective.
Yes.
So very well.
So, my Lord, therefore, my Lord, that after commencement of this act, my Lord, that is very important, my Lord, in this particular context. All that it says that there was a tenancy, you have it converted to lease with the consent, it comes outside the purview of the Premises Tenancy Act. Now, my Lord, I'll just point out, I'll just read, my Lord, what that was there prior to the amendment. Any tenancy where the lease has been registered under the Registration Act before or after the commencement of this act.
That was
That before was, my Lord, taken away.
If that was there, there would be no problem. Mr. Chaudhary would be out of court.
before and after. After the
That has
commencement
been
of
now
this act.
changed by the 2002.
Here, Lord, it is not even before the commencement, Lord. Okay, it is of course before the commencement, that was, but now that, Lord, the statute has changed. It is now only after. So, Lord, what that has been taken out is, Lord, those classes of lease with the consent made after commencement of this act by the tenant are, Lord, coming out, Lord, of the ambit. But this tenant means, Lord, here the tenants which, Lord, are under the premises tenancy act. It doesn't include, Lord, those tenants under the transfer of property. Because otherwise, Lord, the rights, as I argued, accrued under a specific act on which, Lord, a dual relationship was created, but that will get diluted.
That will, this is very counterintuitive, but
yes, but
still,
Lord, that
language
tenant,
has to do.
the word tenant, if your lordship, Lord, generically reads, Lord, tenant can be of any nature. Code for tenant. Let us.
Yes, exactly.
But just for an example. But tenant, when read in the context of a particular statute, has to be read, Lord, a tenant understood in the context of that premises tenancy act. দেখাচ্ছি এখন তো ইন্টারপ্রিটেশন অফ স্ট্যাটিউট আছে
B also distinguishes between tenancy and lease, uses both separate. B.
Kindly see D. D is also any premises rented to a foreign mission.
No, but
the languages.
But B, lease and tenancy. B says any tenancy created by the central government or state government in respect of premises taken on lease.
Yes.
Or requisition. So
yes.
Government takes it on lease
or
and
requisition.
then tenant gives it in tenancy.
So lease and requisition are two incidents under the statute.
And lease and tenancy also apparently. Government takes it on lease but gives a tenancy.
Tenancy, lease and requisition. In B, as your lordship.
Yes.
Requisition is also, Lord, outcome of a statutory provision.
Then lease is equated with requisition. Either taken on lease or requisition by the government.
Or it is or. They're taken
Yes,
to
in the sense vis-a-vis tenancy.
Yes.
I mean, it's taken either by lease or by requisition. The government takes it and then gives it in tenancy.
Yes.
Very good. Very good.
So, Lord, that is my submission so far as, Lord, the interpretation of the word tenancy in 3C. Now, Lord, I'll also rely upon another division bench judgment, Lord, in connection with the second appeal. Lord, all, Lord, are, Lord, building upon, Lord, Prakashvati on the proposition that has
Wouldn't this be a pure question of law, Mr. Mukherjee?
Lord, it has already been settled. Lord, if there is a doubt about the question of law, Lord, certainly it is a question of law to be decided. But now that when it is a settled proposition of law, Lord, when the catena of judgment says that when the lease has been, Lord, allowed to run its full course by efflux, that too in the year 2005, and in 2026, Lord, the question is raised without even raising in, Lord, the defense in the written statement. Lord, that will really, Lord, create hardship to my client. But, Lord, it is up to your lordship, Lord, when your lordship is exercising powers under Order 41, Rule 11, Lord.
No, side this.
Lordship. দাঁড়া আমি তোকে দিচ্ছি আমি দিচ্ছি এনে একটা ডিভিশন না দেখালে হাসনাও না আমাকে Lord, kindly turn over, Lord, to the second page.
Yes.
Lord, or rather, Lord, I will start from, Lord, the first page, the last paragraph. It is an admitted position that the appellant continued to remain in possession of the property in question, even after expiry of the lease by a flux of time. The finding of the trial court as well as the first appellate court that the appellant cannot take the benefit of Section 2H of the West Bengal Premises Tenancy Act or any protection under Section 3 of the West Bengal Premises Tenancy Act is on proper interpretation of law. The defense before the trial court appears to be that although the lease has expired by a flux of time on 15th June 2003, but the appellant became the tenant under the West Bengal Premises Tenancy Act 1997. The said contention is unaccepted for the reason that the lease was not terminated prior to a date fixed under the lease deed, and according to us, the trial court and the first appellate court have rightly applied the it must be the ratio decidendi of the judgment in Pavitra Kumar Roy and decision of our court in Prakashvati Chopra. In Pavitra Kumar Roy, it was held that if the lease was allowed to run its full course, both the lease and the condition contained therein would come to an end and would cease to be operative, and the clause for prior determination would no longer be available as a defense against eviction. The first appellate court partly allowed the appeal to the extent of granting damage, to which we feel that the first appellate court was justified in modifying the degree to the extent mentioned in the said judgment. The concurrent finding of fact arrived at on the basis of the cogent evidence and correct appreciation and the interpretation of a relevant provision of Transfer of Property Act and the West Bengal Premises Tenancy Act 1997, we do not find any reason to admit the second appeal. Similar, the ratio here is that if it is allowed to run the full course and ended by a flux, the Section 3 that is
second appeal. Second appeal. Now we are taking up a first appeal. We are the last court of facts.
But on the question of fact, not that it has ended in 2005 by efflux without a sooner determination, that is an admitted position.
Yes.
That is an admitted.
They are not denying that.
No.
But the applicability of the law, what would be the law?
Yes.
This would pertain to inherent lack of jurisdiction, because court is acting not as a person or designator, but as an authority, because court has been, the statute might have vested the rent controller also, as previously done.
Lordship.
So it's a statutory authority which has been vested on the court. So therefore, I mean, this would be inherent lack of jurisdiction if.
Lord, if your lordship so holds, Lord, that there is a, then Lord, the question which were decided previously by the division benches and even your lordships, Lord,
that's
about that portion, Lord, to
yes,
which
we'll
my answer is that
these are our own judgment. We'll have to hold that all those are par curiam, the par incuriam, the statute. That should be a very high ground.
Lordship. And Lord, to my knowledge, as Mr. Chaudhary also knows, Lord, this particular judgment of my Lord, in reported in Lord 2021 ICC, Lord, as against this, Lord, a SLP is pending. I'm told, Lord, not an SLP, but Lord, SLP has been admitted.
Appeal is pending.
Appeal is pending.
No, stay has been granted. That's a different rule.
No,
that is not relevant. Yes.
Because this is not a reported.
Stays on the between the parties, not on the proposal.
That is a reported one to the extent of Lord during the pendency of the SLP. One of the parties, the landlord, asked for Lord the occupational charges. On that score, Lord, the Supreme Court has deliberated on it. Lord, that is reported in 2024 volume 8 Supreme Court cases 668. তুই যেটা দেখালি সেটা 2020 থেকে
mean profit দিতে হবে before decree.
This was for right. That we said 142. That one. Under Article 1 for
no, that
one
your
judgment
lordship
here
in
it was
this judgment your lordship held that it is covered under, in the facts of this case, it is covered under Lord the transfer of property.
Yes. Oh, acha, they claimed occupation charges.
Lordship. In that Lord appeal before the Supreme Court, because this your lordship held that 111G is a sooner determination, therefore Lord it is covered under Lord the premises. That is Lord.
So what was that? That's an order passed in connection with that appeal.
Yes, that is a Lord concerning the occupational charges. The point is not decided.
This is still pending. The appeal is
that is still pending. That is Lord from the 2020 Lord that is I mean the 2019 decision of yours, which was handed over today.
Yes.
Ashwin Bhanulal Desai.
Oh, acha. So that's a different thing. What's against this?
Again, yes. Not from Charu Diesel. Charu Diesel, another SLP, according to my learned friend.
All my judgments are now suffering SLP. Let us see what happens. But all are pending.
All are pending, Lord.
No, we cannot take note of that pendency. I mean, we can take note of, but that would not be a deterrent. We have to, if that's not decided in the meantime, then we have to proceed on the basis of this judgment.
Yes.
And we have to consider whether this is
Lord.
pardon period.
And the fact of this case, Lord, and the facts of these cases, Lord, these are quite different. I'd say. But none of the cases, Lord, start with the fact that, Lord, the leases have been, Lord, started prior to coming into force of, Lord, the premises.
Yes, there it started comments during the 56 Act regime.
But this one, Lord, it is much before, Lord,
Yes,
any of
in
the
your
premises
case,
change.
it started under the 97.
In 56 Act, if it had started, Lord, the flow of, Lord, how the law has evolved concerning, Lord, the 3C, that was not in Prakashbati.
So you say that the inception, the point when the jural relationship was entered into, that should be the
That is a governing, Lord, the law
governing
between the parties.
point of time.
It cannot, Lord, as it fell from your Lordship, it cannot alter the course until unless, Lord, there is a specific statutory embargo saying so, not by necessary implication. My learned friend is saying that you kindly imply into it. By implication, Lord, the right cannot be created, cannot be denuded.
Good.
That's all for me. Sorry.
Yes.
But I think I'm wiser in the last half an hour on section 3. I just want to include
All of us.
after hearing my learned friend.
Even Mr. Mukherjee has grown wiser after hearing himself.
That really happens, Lord.
Yes,
Always happens. Always happens during arguments.
Really happens, Lord.
While at the bar during arguments, so many points are developed during arguments.
That I'm looking at section 3 in a different light today. 2G definition of tenant is very wide. Your Lordship has read it so many times. So it tells you what is a tenant. Who is a tenant? Milord, definition clause says nothing, Milord, more than that. Also says what is a premises.
There is no clue in premises, landlord and tenant definitions.
Yes, just 3 definitions. Now, Milord, as I said, 1, Milord, has the extent of the act. 2 has the definitions. Now, Milord, please see section 3. 3A.
Yes.
D, E and F relate to premises. And, Milord, B and C relate to tenancy.
Yes.
Then, Milord, from section 4, rest of, Milord, the act, Milord, there is no specific section for, Milord, incidents of tenancy, etc. Now, this is how it's created. That's included in definition of tenant. Milord, what will make a tenancy? Milord, a tenant means any person paying rent, etc., etc. Then you've got landlord. So landlord, premises, the subject matter of tenancy. Then there's a landlord who's receiving rent, tenant paying rent. That, Milord, creates the concept. Now we come to, Milord, 3. When you see 3C, it says any tenancy where lease has been registered under Registration Act. So I agree with Mr. Mukherjee. It is a tenancy which comes under the Act.
56 Act.
56. No, Milord.
Or maybe this Act also.
This Act. Milord, 56 Act, Milord, I'm not considering, because if your Lordship sees, and that will also answer my Lord's question, Milord, kindly see section 45. Yes, Milord, 45. Milord, the 56 Act is repealed, and subsection 2 says it's only continuation of proceedings.
Not acts.
Not acts, not rights, only proceeding.
Yes.
Under 97 Act, fresh creation.
Yes.
Now, what I want to argue is this, Milord, that there is a tenancy which is created. So everything, if definition of landlord applies to my landlord, and definition of tenant applies to me, and definition of premises applies to the subject premises, and if all 3 of us come within the territorial limits, Milord, under section 1 and 2, I become monthly tenant. That's the scheme of the Act. Then we come into section 3. Now both some tenancies go out, some premises go out. So premises of central government, state government goes out. Tenancy, then B, my lord, is tenancy created by central government of its leased or requisition premises goes out.
We are not very confident on the distinction between lease and tenancy being deliberate in the statute, because it appears to be used interchangeably some places. If you come to F,
yes,
any premises let out. Let out is the verb of lease.
Yes.
It should have been tenanted then. Any premises tenanted for, or tenanted out even. And explanation also let out. E says any premises let out.
F also says that.
E, F both. And now therefore, again, any tenancy created by a foreign mission.
Explanation also, my lord, says
He
let out.
uses any premises rented to a foreign mission.
My lord, but
So
B,
the entire thing used interchange. Let out, rented, tenanted.
my lord, try to, my lord, put some meaning into let out. But my lord, if I look at B and C, both say, my lord, existing tenancy.
Any tenancy does not say existing. It says any
tenancy.
tenancy created
Yes.
by the government in respect of the premises
Yes.
taken on lease.
Yes.
So you take it on lease, the government takes it on lease. So
Or
basically,
requisition.
it's government premises.
Government
Taken
premises.
on lease or owned
And
is
then
covered
given
by
on tenancy.
has to be given on tenancy.
No, then second step, my lord.
Second step, yes.
Second step.
Yes, yes. Not
Tenancy created.
Yes.
So that goes out. Then a tenancy where lease has been registered under
E
registration.
and D are understandable probably because of the 1971 Act, the Public Premises Eviction of
Yes.
Unauthorized Eviction.
There are two state statute also.
Our state also has a
Yes,
statute.
we have corresponding
No,
statute.
our state statute, nobody is not looking at. I'm
Yes,
very
yes, we have
surprised.
to look at.
62 Act.
We have
Not
to
so
look at.
much
You
we
don't have
see
to
on
look at.
Instagram.
You look more towards this Commercial Courts Act.
No, I look at Instagram.
We have to look at this Land Tribunal Act, Commercial Courts Act, Arbitration Act, and again come down to this
No, that I know, Millard.
state statute regarding
That I know.
artisans and all.
No, that I know. I'm only saying.
Exploiters as well as the exploited, both come before us equally. So we have seen everything.
No, I didn't mean that. I said looking at what is happening around us, all these bulldozer reels which I watch on Instagram, nobody is looking at the ordinance, the act of, the West Bengal Act.
People are looking at. We can assure you.
Now, Millard,
yes,
that's a very anti-establishment comment from me.
Not that. It's
lawyer's curiosity.
Fair criticism. Why not?
Now, but Millard, what I want to say here is on 3C, a tenancy created by a lease. Now, please, this is something I never stressed on.
Request you to file written notes of arguments, and you see how confusing it is to put it down in writing.
I would never be able to
decide. Both of you learn a lesson, Mr. Mukherjee. You know the lessons already.
No, I would never be able to decide. It is terrifying.
You put it on paper and then you'll understand how difficult it will be to write this judgment. You have to put it in paper first in the written notes. Just see how difficult it is to put this idea into paper. What is crossing through your mind and Mr. Mukherjee's mind. Both the ideas. Put it on paper and we'll take those written notes of arguments and copy paste where necessary. We'll put it in a cauldron and just like the witches in Macbeth. Just go. So you have argued. You put it on paper.
Just 4 sentences.
Yes.
Number 1, 3C relates to a tenancy which comes of a lease. Because it says any tenancy where lease has been registered. This only
tenancy is not defined. Tenant is defined. Tenancy is not defined. Lease is not defined. How can you say that?
Lease is always defined.
How can you infer these things?
Lease is defined under Transfer of Property Act.
Yes. But
So
not under this act.
Tenancy is under this act.
No, but in the definition clause, is there anything to say that wherever there is no specific definition, then Transfer of Property Act definition will apply?
No, but that's the usual aid of interpretation.
No.
If it's not defined under this act, look at General Clauses Act, not defined.
Parliamentary statute.
But it's a Lord, may I, lease is not a transfer of property, a mode of transfer of property, which has great bearing here. So lease can't have two meanings. But will not kindly see just the definition.
Then let out also can't have two meanings. Let
No.
out is a verb of lease.
Let out maybe, or maybe let out is for covering both Milord, tenancy and lease. But Milord,
Lease also covers both tenancy and lease. Tenancy also covers both lease and tenancy. These are words used in the statute without defining them. So you can put your own interpretation.
But tenancy is nothing but monthly lease protected by an act.
Under Transfer Property Act, lease is also monthly lease is also a lease.
Yes.
So lease is nothing but a monthly tenancy.
If it's protected, it's not tenancy. If it's unprotected under Transfer of Property Act, it's a monthly lease. That's the only way to go by. But Milord, I find great solace in the definition of tenant, because it really says that I have to pay rent for a premises. Premises is defined, landlord is defined. And then 3C, Milord, has great bearing because it says tenancy where lease has been registered. So it itself indicates that where there is a lease, there can be a tenancy. And 3 points I noted down because otherwise I'll keep repeating. So I'd better stop. 3 points. One is, Milord, Prakashvati, the judgment. In my humble submission, Milord, the judgment can have no application. It relates to 1956 Act, which had that very difficult definition about continuation of lease and termination. It is for that reason that the law was laid down, that if the lease is allowed to run its full course, then Rent Act will not apply. It is apropos that. Now, with that definition gone, it's now the definition is now cleaned up because of 3C. So Prakashvati can have no application. Bengal Steel can have no application. Next is, Milord, Ramesh Mitra judgment, Milord. Two distinctions. Number one, that was a case where there was an existing right under, Milord, that 2G.
It was not cited by Mr. Mukherjee.
Milord, I've got it by WhatsApp.
No, I've got it printed.
Yes.
Which
paragraph, Mr. Mukherjee?
17 to 21.
Oh, yes.
17 to 21.
That related to protection under Rent Act. Protection under Rent Act is an accrued right. Here, Milord, this is transfer of what is there, what was being taken act is protection under Rent Act. So, Milord, different consequences apply. Stricter interpretation. Here, Milord, under General Law, Transfer of Property Act, there is no protection. Nothing is being taken away. Then I think that I'll file my note, Milord, if your Lordship permits me.
Because you will have to grant stay in the meantime, otherwise.
But in the meantime, we are not proceeding, Lord. We can assure, because on the last occasion, I said it is not fixed for SR and AD. So, Lord, the next date that has been given.
No, but we can't take the risk.
Adjournment has been granted, I'm told.
Can't take the risk, Mr. Mukherjee. Suppose your client takes a change and puts somebody else, and
that might be a possibility of.
No, Mr. Mukherjee. By your
but kindly makes it, Lord.
Limited.
But it was very interesting.
There are already 5 pending series, so this will take some time. Not
Is it
much.
that your Lordship requires, Lord, a written notes from us, or your Lordship has?
No, we want to. To fix liability on you for whatever we write. So both of you will file written notes of arguments,
Very well.
and those will be on record.
Very.
So the hearing is concluded. Learned counsel for the parties are requested to
There is
file
a Section 5 application which.
It is Section 5, I think.
How many days?
Kindly allow.
That is the last date.
Section 5. How can you say kindly allow?
By 2025.
321 days only.
না 300 একটা ভুল করেছে কারণ 3 months
I need
বাদ
to
যাবে
point out.
But I thought that he will be starting
I
with
didn't
that.
even know that. I'm sorry, Miller. I should have pointed out.
Let us
Miller,
reject
kindly-
that. Let us dismiss. Yes, what is the ground of?
The
Miller,
ground,
kindly-
Lord, I'll take your Lordship.
Mr. Mukherjee
There will
doesn't
be
allow
dismissal.
continuation.
Definitely. will be. Now we are convinced. Yes.
Hey, Jhamela koi na.
What is the ground? What is the ground? You have to move your ground.
Milord, I had no control over the advocate, Milord. My brothers were
We'll
looking
kindly have
after
a
it.
look into paragraph 12 and 13. These are the only two grounds.
Hey, Jhamela koi.
ঝামেলা? মক্কেল করেছে আমার lawyer দায়ী।
Okay. Then what? 12 and 13 is after
The judgment is not in 2025.
No, actually, we didn't know. My brothers were
Okay.
contesting.
Not
appraised.
It was.
Pass expertise.
And Lord, kindly see Lord 13. In the said circumstance, there has been no delay or latches on the part of the appellant. The delay, if any, on the part of its learned advocate may be controlled. And
Given
if I
notice to
take
the-
your Lordship, Lord, to the previous Lord, statements, Lord,
Okay.
not very happy. Kindly have a look into Lord the paragraph at Lord.
No, this is actually what has
Six.
happened. My brother joined hand with the landlord, my relatives. So we came to know. No, not advocate.
It is not a case made out.
Why should we blame an advocate?
That is what exactly that has been done in the application.
No. No, Milord Malafide is ascribed.
Paragraph 6 or
Their advocates appeared. So we gave a vokalat.
and there is also another appeal against the same judgment and degree by another tenant. This is not appearing in the list. That your Lordship may ask to be
Paragraph 13, you say that in the circumstances there has been no delay or latches on the part of the appellant. There's a 1 year delay. You say there's no latches. The delay, if any, on the part of its learned advocate may be condoned. You're so condescending on the advocate. Let it be condoned. The advocate's delay may be condoned. I have no latches.
Paragraph 11 is not only the advocates, the delay is from 30th of June. Paragraph 11.
Then actually there was no contest. I wanted to contest the suit.
Contest.
There was no contest. That is the problem.
After 20 years, they come up and say that they're.
Now, if you dismiss it, will appear that actually. So you pay some costs. Pay some costs. How much will be commensurate with your client status? Business. Mr. Sarogi does business.
Yes,
As Mr. Mukherjee suggested.
The monthly rent for the premises we have assessed 17 lakhs. 5-story building in Bada Bazar. 11 cutters of land.
They're full of subtenants who pay 5
That is
rupees.
not, he is gaining from the subtenants. I am not.
We find from the averments made in Can 1 of 2026. That the delay in preferring the appeal has been sought to be condoned.
What is wrong with you?
On the ground that the appellant had relied on his co-tenants and was initially in the dark about the outcome of the suit in the trial court. Next para, subsequently, comma, upon coming to know of the same, comma, some time was lost in getting the certified copy and a certified copy of the impugned judgment and degree and preferring the appeal. After having this memorandum drafted. Next para, senior counsel appearing for the respondent seriously opposes the prayer for condonation and points out that the cause shown in the application is not satisfactory. Upon a perusal of the application, comma, we find that although the reasons given for the delay is somewhat unhappy, comma, on the premise of the averments made therein, comma, we do not find anything to specifically fix malafides or lack of diligence on the part of the appellant. Full stop, next para. Be that as it may, comma, since the delay is of almost a year, comma, we are of the opinion that the respondent should be compensated with costs, even if it is condoned. Full stop, accordingly, can 1 of 2026 is allowed, thereby condoning the delay in preferring FAT 262 of 2026 on condition that the appellant pays costs of rupees 10,000 to the respondents within plaintiff stroke respondent numbers 1 and 2 within a week from date. Full stop, next para. The appeal is taken up for hearing on consent of the parties in view of the short point involved. Full stop, hearing is concluded. Full stop, the matter is reserved for judgment. Full stop. Can 2 of 2026 is disposed of by granting stay of operation of the impugned decree and or any connected execution case, if any, till disposal of the matter. So we'll try to be as fast as possible.
Clerk, but we'll file our written notes by Monday.
Oh, yes. Learned counsel for the parties are matter is reserved for judgment লিখেছি কি? Hearing is concluded লিখো, reserved for judgment করে দাও. Learned counsel for the learned senior counsel appealing for the parties are requested to file the respective written notes of arguments of the parties on, give us a date.
But Monday? Monday পারবি তো? So Saturday, Sunday, okay.
On July 27, 2026, when the matter shall be listed under the heading to be mentioned for such purpose.
Let me appear on Tuesday. Both of us are not here on Monday. So Tuesday will come.
July 28, 2026. July 28, 20.
Much
To be mentioned, July 28.
Great.
বইটা ফেরত দিয়ে দাও। Thank you. আমাদের এর পরের আর কিছু নেই, এর পরেরও বেয়ার অ্যাক্ট আনিয়ে নিতে বলবেন 56 এ বেয়ার অ্যাক্ট পাওয়া যায়। থ্যাংক ইউ। এত গরম অবশ্যই থাকবে, ছেড়ে দিন, থাক। যদি ওকে থাকে বেয়ার অ্যাক্ট তাহলে আনিয়ে নিতে বলবেন, কোর্টের জন্যই বলছি এটা, তাহলে ফেরত পাঠান। এটা যখন প্রথম স্ট্যাটিউটটা এনাক্ট হয়েছিল তখন করবে। নেক্সট।
Lord, may I start?
Yes.
Our appeal, my lord. Lord, notes have been bullet points, my lord. I have prepared the notes. I'll hand up, my lord. My lord has also given his.
We also my lord prepared, my lord, person to my lord's today.
Some statement was filed by whom? This was by appellant.
My lord, the appellate
Statement.
Oh, that
that was the comparison of the
comparison, my lord, of
the
the
plaint, my lord.
paragraphs,
Plaint, my lord, of the paragraph of the plaint, my lord, he had filed.
where, my lord, we say, my lord, what is the cause of action, my lord, and
My lord,
Can you release the other matters?
yes, yes, my lord.
Other matters are released.
I'm very sorry, my lord. Last day I came running, I missed the matter.
No, no, no.
I'm very sorry for that.
Why should you? Yes.
My lord, suit, my lord, as framed by the plaintiff, I am the plaintiff, my lord,
Yes.
is for disparagement of my lord, my products in question. My lord, those are bombs, lordship has seen it, my lord. My lord, in the advertisement, my lord, which is before your lordship has seen it, my lord. My lord, none of my products have been pinpointed. It's a round shaped bottle with a cap. It is shown in the advertisement. I go, my lord, and file a disparagement suit and obtain an order of indictment.
Yes.
My lord, my learned friends, my lord, it's an appeal, my lord, from an ex parte order. So, my lord, naturally, the contents of my plaint has to be taken as true and correct. One has to proceed on such basis and proceeds on the averments made by in the plaint on a meaningful reading of the plaint. Now, my lord, for the first, my lord, in respect of a dispute of disparagement, my lord, one has to see where the dispute arises from. The dispute, my lord, arises from an advertisement. Maybe, my lord, a print advertisement, or maybe, my lord, a electronic advertisement, or maybe, my lord, something, my lord, coming in our, my lord, social networking system.
Yes.
My lord, then, my lord, one has to see, my lord, the grounds on which I have sought the relief in the plaint. And a cause of action, my lord, which I am espousing before your lordship or before the court. And, my lord, the relief which I have claimed.
Yes.
These are, my lord, the four parts, my lord. Now, my lord, my learned friend's case, my lord,
is that, my lord, this is covered by section 29(8). By reasons whereof, my lord, it's not, my lord, it's covered, my lord, under the Trademarks Act.
Yes.
It is, if it is covered under the Trademarks Act under section 29(8), my lord, then, my lord, trappings of commercial courts come into operation to section 2C170. Hence, my lord, the order passed by the court below is a nullity. Or, my lord, it's, my lord, without jurisdiction. I may put it this way.
Yes.
To that, sir, apni take over court. So, my lord, the first question, my lord, which I say, my lord, if your lordship takes the act in question, I will just if your lordship kindly have a look at section 29, subsection, my lord, 8. Has lordship?
Yes, yes.
A registered trademark is infringed by any advertising of that trademark. So, my lord, the registered trademark is infringed by advertisement of that particular trademark. A, my lord, takes unfair advantage of and is contrary to the honest practice in industrial or commercial matter, is detrimental to its distinctive character, or is against the reputation of the trademark, of that trademark. So, my lord, it presupposes for invocation of section 29(8), the plaintiff's registered trademark should be displayed on the advertisement. It should be pinpointed. It must be used. It should be displayed.
You can also come to 9 once.
9, my lord, is, my lord, perhaps, my lord, not, my lord.
Not applicable.
Material.
Oh, where the distinctive elements. Sorry.
Yes. What is material, my lord, is, my lord, 29(8). For that, my lord, the first one has to, my lord, see, my lord, whether my registered trademark is used. So, my lord, advertisement is before your lordship.
Yes.
My lord, in that, my lord, bottle is, my lord, displayed, my lord, where on the advertisement as floated by my learned friend's client, my lord, there is no, my lord, representation of my trademark. My learned friend's argument is, my lord, that, my lord, since I have annexed, my lord, my registered trademark, and I think by way of innuendo, my lord, these are reference to me, I am covered by 29(8), but the section doesn't speak of infringement of, my lord, that, my lord, can be by displaying of that trademark. All right. So, my lord, section 29(8) on registration goes out.
So there cannot be a passing of sort of paradigm introduced into this.
In 29, my lord, I'll put it in this way and I give, my lord, to my learned senior friend to, my lord.
The striking resemblance won't be a factor.
My lord, look at the section, my lord.
Section does not say so.
That doesn't say so. My lord,
That's
if
what we are
lordship
saying.
takes, my lord,
Passing of action sort of that sort of premise cannot be brought into this.
Now, my lord, it, my lord, what was shown, my lord.
Yes.
I get very nervous, my lord, if he's sitting on this side, my lord. That side, I don't have any. No, I don't. I don't have any.
Mr. Bachawat is more nervous after hearing.
No, I am very nervous. I get very nervous. Either he or he sits in that side, my lord. Other side is fair.
It's counterbalanced now.
Yes, now it's counterbalance. My lord, kindly have a look at section 2 Commercial Codes Act now.
Yes. 21C, 17.
Kindly
we read it ad nauseum yesterday. When
someone... This is, my lord, lordship. I was hearing, my lord, lordship was, my lord, I, my lord, sat because of for my interest under, my lord, that tenancy act.
The previous, no, not the previous one.
On a different I sat, my lord, in the court because of my interest, my lord. What is the interpretation of, my lord, the 2002 amendment, my lord?
Yes, absolutely.
Then, my lord, what fell from, my lord, my lord, that retrospective effect, my lord. That I was hearing, my lord. So, my lord, kindly have a look at, my lord, 2C, my lord,
17.
1C17.
Yes, intelligent.
My lord, 2C, my lord, start. Commercial dispute means a dispute arising out of. So, my lord, means. Now, like in, my lord, legal parlance, my lord, means, my lord, what does means mean? Exhaustive, my lord. This is all it is written here, my lord, that is written here. So, my lord, this cannot be, lord, 217, 1C17, where Lordship comes, my lord, kindly to the section. Intellectual property rights in relation to a registered and unregistered trademark.
Means relating to us.
Means, my lord.
Means arising out of relating to.
Relating to. So means, my lord, first, it is, my lord, exhaustive. Whatever is there is there. This is the first one. And relating to registered and unregistered trademark.
So arising
So
out
the
of and relating.
registered trademark, 29(8) Lordship has seen in respect of an advertisement. My lord, akin to, if it was an unregistered trademark, it could have been. It is not the case. If it was an unregistered trademark was shown.
Then also.
Then also maybe. But here it's, my lord, neither of, my lord, the limbs are fulfilled.
Trademark is not shown at all.
Not shown at all. So, my lord, this, my lord, arising out of, in relation to, doesn't, my lord, help the, my lord, my learned friend's case. Then kindly, my lord, permit me.
Madam, I'm sorry.
Yes, yes, please.
এখানে ইন্ডেক্স তো করা আছে তাহলে আপনি বলে দেবেন নোট ইন্ডেক্স
Yes, Mr. Vajit.
So, Lord, once is not identified the slots, if I may just not frame the question here. So, Lord, the question would be, Lord, is a suit for disparagement, Lord, a suit which is not a suit arising out of a registered or unregistered trademark? This is one question. And if I may reframe the question, which is what we are actually concerned with, is this particular suit one, not a suit for disparagement, where I am clearly saying I am not claiming any right of relief for passing of an infringement? Will this suit be one for disparagement? Rather, will it be a commercial suit because it arises out of a registered or unregistered trademark? So, this is twofold. One, generally, the other is whether in the facts of our case.
Yes.
Now, here, there's an interesting interplay. Lord, your Lordship has seen all these sections, so I won't read it just now, apart from one more section. But, Lord, when my learned friend was placing 29,
yes,
Lord, the object of this clause, this was not there under the 58 Act. Lord, the 58 Act was not restricted to, Lord, just for a second, just have a look at section 29. Only 29(1) was there. Only 29(1) was there.
Already.
Not these rest of them have come in later. Okay. So what they've done is they've expanded the types of infringement that there may be. So the varieties of infringement, the categories have been expanded. Now the object of 29(8)
yes,
was really to take note of comparative advertisement. This is what it's about. It's comparative advertising. In other words, if I am comparing my product with his, and in doing so, I use his trademark to identify him, then it will come within this. This was the object, to bring...
His trademark has to be shown in your advertisement.
That was the... that's a prerequisite for 29(8), because it says this is infringement which is taking place.
This is registered one of the species of infringement.
Correct.
For which you have to show his trademark in your
Correct.
advertisement. That
Correct.
is the argument.
Correct. Because of
by any advertising of that trademark. Very.
In advertising my trademark, if I say that his goods are bad, and for that purpose I identify his goods by the trademark, then it would be trapped here. In other words, I must use his trademark in my advertisement. This is the object. Comparative, as your Lordship knows, comparative advertisement is permitted, but not if it makes unfair use of the other person's trademark. I can always say, look, there are 10 products in the market. I can put the prices of each in a table and I can put it in. No difficulty. But in doing so, if I use his registered trademark, then that advertising would be hit and be an infringement if not it falls within ABC. This is the object of this section. Now I'm not moving back one step from here. But To summarize it in one sentence, my lord, Trademark Act expanded to bring in another new species. If 29(8) is to be attracted, not one of the prerequisites is that he must use my trademark or the plaintiff's trademark. Now, my lord, I won't use mine and yours, but not the plaintiff's trademark must be used for 29(8) to apply. This is a prerequisite. Now, my lord, let's leave this apart. Now, my lord, let's look at disparagement. Now, my lord, disparagement.
Doesn't even require a comparative thing. I mean, advertising of that, and it may be very gross. He advertise his product and put something in which derogates it.
Let's take an example. Let
That
me
would be
think
very
about it.
gross, but people don't do that. But may be done.
But it could be. Let's take it theoretically. In trying to advertise my product, I say, let's say I'm not advertising something like not Amul, not lassi. So I say we are the largest manufacturers. I show my Amul lassi, and then I show the rival. I say the rival, and I show a dirty factory with cockroaches running around over there. And I call it a rival.
Choose some other insect or animal.
Very well, not snakes.
Cockroach is not the right word. Allergic to that.
So, Lord, that's the first animal which came to mind because it's all over the newspapers now, Lord. All over the newspapers.
Insect.
So, now, Lord, so there's an insect infested factory, and then I show the name.
Yes. So someone is vomiting by drinking that or something like.
When I show that name, Lord, then in that comparative advertisement,
yes,
that would be, Lord.
Very good.
Now, Lord, I will call this loosely, although the word disparagement is not used here, but this is statutory disparagement, perhaps.
All right.
I'll call it that. So it is a species of disparagement which is protected under the Trademark Act.
Yes.
Now, Lord, let's look at trademark, Lord, or rather disparagement in general. Now, Lord, disparagement is basically saying that someone else's product is bad.
Yes.
Now, why is that different from passing of an infringement? In passing of or infringement, I do just the reverse. I don't say his product is bad. In passing off, I copy his product and pretend my product is his. So I get the benefit.
Yes.
So I'm really saying that that is a good product. In both passing off and infringement. That's the real difference.
No, in other species of infringement, you can also do that.
Yes, under 29(8) species.
29(8), yes.
29(8),
Yes,
I'm clearly using his trademark.
Obviously, yes.
Here, wrongful use of his trademark, but pretending I am him. Yes. That's the difference. But the complete difference in the two species of things. Disparagement and not passing off an infringement are diametrically opposite. In one, I'm calling his product bad. In one, I'm actually flattering him by copying him.
Yes.
But they say copying is the best form of flattery.
Yes, mimicry is the best flattery.
So,
yes.
So, this is the basic difference.
Right.
One, I'm vilifying the rival. Disparagement, I'm vilifying his products. Passing off an infringement, I'm not doing that.
No, that is very clear, Mr. Vajat. What we were meaning by saying passing off is.
I'm coming to the third part.
Is the other aspect of it.
I'm coming.
Specifically not used, but yes.
I'm coming to the third.
Deceptively similar or something.
So, my lord, as your lordship has put it, not therefore, while disparaging someone's products, it is also possible that I have an additional, not the plaintiff may have an additional cause of action when I'm disparaging it, in the process of disparaging it, I also show his trademark. Right. For the purpose of identification. To identify his product, I use his trademark. That is what gives rise to the additional cause of action, which is 29(8). So all forms of disparagement will not be infringement or passing off.
No.
But a sub-variant of it is, it's an additional cause of action given under the Trademark Act. This is how I would put it, not if I have to put it all, tie up the ends.
Right.
But in that additional form of not cause of action, that additional cause of action 29.8, that not presupposes use of
Trademark.
the rival's trademark.
Yes.
So, Mulad, if I may put it differently, there is no cause of action if the trademark is not used under 29.8. So, question of infringement will not lie. Now, Mulad, everything I say here, fortunately for me, everything I've said here is actually being held by your lordship. Your lordship has already held that, and I'll point that out last. Now, there is one other factor before I go to the 2C factor and before I show the judgments. There's one other factor, and I can't say I have a complete answer to this. Not your lordship was looking for food for thought. Not maybe this is.
So we are not at all looking for any food for thought. We have sufficient food throughout the morning.
No, that's been well.
We have been tenanted, now you're disparaging us.
But I'll leave the food for thought for the next day in that case, because I don't think we're going to finish in 10 minutes.
No.
Next
You can start with that.
So, Mulad, please have a look at
the time constant will shorten your argument.
No, Mulad, I'm going to be very short because I'm going to distinguish their judgments and I'm going to cite two judgments.
You can start.
But please have a look once at section 134, which is the
Yes.
Jurisdictional section, which your lordships are aware of. Suits for infringement to be instituted before the district court. No suit for infringement of a registered trademark or, now Mulad, please see B, relating to any right in a registered trademark. Mulad, just make a mental note of relating to. For passing off arising out of use by the defendant of any trademark which is identical or deceptively similar trademark, whether registered or unregistered. Now let's see the use of the words here, whether registered or unregistered. This is language similar to what we have in 2C17. This relating to and whether registered or unregistered.
Yes.
Now, I can't say I've been able to draw a complete not logical answer to all of it, but I'll try and tie it up. Shall be instituted in any court inferior to the district court. So now, my lord, your lordship is seeing three categories which are to be filed not in a court not inferior to district court. Infringement of a registered trademark or not any right in a registered trademark or for passing off arising use of a trademark, not whether registered or unregistered. So these are the three categories of suits which has to be filed in a court, not district court or
ADZ.
So this is the given situation. Now, I'm not immediately trying to tie it up with 2C, but not if, because your lordships have read it too many times, but not, please just not look at the words of 2C17 now, Lord, once. Not because I'm giving it a slightly new spin, which may not have come up before. So, 2C17, not as Mr. Ghosh has said, commercial dispute means a dispute arising out of, and 17 is intellectual property rights relating to registered and unregistered trademarks. Copyright, patent,
language, the similar language of
yes.
Yes.
So, that registered and unregistered is there. Now, the first comment I would like to make here, is Mr. Ghosh has already said means. I'll add just one little small thing to it, and your lordships, I don't think I need to, but it does not deliberately and consciously does not use the words means and includes.
Yes.
It's not an inclusive definition, and the Supreme Court is clear that it's a restrictive meaning.
Yes.
So you either fall within this or you don't. Now, coming to 17, the way I would read it is commercial dispute means a dispute arising out of intellectual property rights. Intellectual property rights and then restricting it to these variants.
Yes.
So, not if that is the situation, first thing to mention, the word disparagement is not included. Now, is it because disparagement does not fall within intellectual property rights? Disparagement doesn't fall at all.
No. How can
But,
you say that?
correct. So, not 29(8) would fall within.
Yes.
Disparagement is not a species of probably violation of an intellectual property right. It is a common law right, defamation. It's a variant of defamation.
Yes.
This much is clear.
Yes, but it still pertains to intellectual property rights relating to.
It may. What I'm saying, it may sometimes relate to.
Yes.
It may sometimes where it is coming under 29(8). This is what I'm pointing. If, for example, the plaintiff's mark is not identified in the offending advertisement,
Right.
then there's no trademark involved.
No, you are saying that there can be disparagement without coming within
Without it
29(8).
being an intellectual property dispute. Let me put it crudely. Not every, or let me put it in a reverse form. Will every disparagement action be a trademark dispute? Answer must be a no.
But intellectual.
But some may be.
Yes, disparagement. Why not any disparagement action, any disparagement connected to a trademark, relating to a trademark?
That's
is an intellectual property dispute relating to a trademark.
That's why I framed
Whether
it.
coming within 29(8) or not.
Absolutely not. Now, that's why I put it in the form of two questions. Is every suit a disparagement coming within commercial dispute? And is this one coming within?
Yes.
That's the variant. Now, let me take it higher than that. Can it be said that defamation, I'm using the word defamation consciously, that defamation would be a violation of intellectual property right? Answer possibly is no. And no authority is being shown. Now, would disparagement be a violation of intellectual property right? If I am correct in my submissions and I intend to show it, disparagement is merely a species of defamation. Vilification of goods. It is not a species of violation of an intellectual property right unless a intellectual property is actually used.
Right.
So if in his advertisement he had showed my bottle with the name Jhandu on it, it would be a violation of my right in the trademark, registered, unregistered, whatever.
But if there is a disparagement without using specifically your trademark, the effect of that will be also on the
goods, on the goods, my business, which is what defamation is about.
No, if you
it may happen that not as part of my business, I may have 10 brand names because goods are necessarily sold by brand name now in today's world. So, it is like this. Not everything will ultimately have an effect.
No, you are trying to distinguish in disparagement of goods.
Yes.
And
disparagement relates to damage to
trademark.
Goods, damage to goods, vilification of goods,
so
vilification of business.
Very well. Generic disparagement is a vilification of goods, products.
Not generic or non-generic, whatever.
Disparagement is.
I'm saying just like defamation is basically vilifying a person.
Yes.
Disparagement is not person but goods. That's the difference. Basic difference.
It's not a vilification of the trademark.
It may end up being. It may end up being.
Very well. But can the goods and the trademark be separated, divorced?
Let's look at it like this.
Can you divorce a trademark from the?
Let's look at this from the point of view of remoteness of damages. Now, if he is not showed my goods and I charge him and I ask for a decree, would I get a decree for damage to my trademark? Because he says, I have not used your trademark. So it will be damage to my goods and business.
All right. They will. So, hard in part for further hearing tomorrow.
Yes. First matter. What they going to take away.
Oh, কালকে
First matter ওখানে
টপিক কি আর কিছু আছে? যেরকম অর্ডারে আছে অলরেডি